Good morning. This is the Energy and Carbon Management Commission for the state of Colorado. It is Wednesday, July 15th. It is 9 o'clock. This is our normal business agenda. We start with a roll call of commissioners.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
Good morning, everybody. Good to see everybody. We have a quorum. We exist. We move through our agenda. We start with commissioner comments. This is the stage in which if the commissioner has comments for the rest of us, we talk to each other. Seeing none, we move to consent. Anyone have questions on consent? Seeing no questions, I move to approve consent. Do we have a second?
Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
Anybody opposed? Motion carries unanimously. We move to the Martinez Irwin Fund discussion, an agendized item with Director Julie Murphy. Good morning.
Good morning, Chair. Good morning, Commissioners, and thanks for everybody who's tuning in. Before I jump into Martinez Irwin, I just wanted to flag that this is my last hearing with this commission and just wanted to express my appreciation for the time I've been able to support the commission, from my time as an Assistant Attorney General, through the volunteer commission and through helping support this commission become a full-time professional commission, and what an honor it's been and what capable hands Colorado finds itself in. So I wanted to briefly say that and say thank you to each of you and to all of the staff that is supporting this along the way, as well as our stakeholders. And with that, I would jump into the Martinez Irwin presentation or discussion. And, by way of background, I want to acknowledge that in 2020, this commission established the Mark Martinez and Joey Irwin Public Projects Fund with settlement dollars from a Kerr-McGee onshore settlement. And since that time, the commission has approved projects that met the objectives of the fund, including air emission studies, measuring to better measurement and identification of better integration of ECMC and CDPHE efforts, methane hazard assessments, and purchases of equipment as examples. In 2024, the commission approved an amendment for the order that extended the final accounting deadline to 2029. However, I'm here today with the agreement of Kerr-McGee to request final disbursements from the Martinez Irwin Fund, which would conclude or wrap up the fund. I'm requesting funding for a final project in the amount of about $15,000 and then a final distribution of all remaining funds from the Martinez Irwin Fund into the Orphan Wells Mitigation Enterprise Fund. The final $15,000 project would fund efforts to mediate resolution of pending lawsuits between ECMC and an operator at an amount not to exceed $15,000. As I noted, the lawsuits involved ECMC enforcement proceedings against the operator related to, among other things, spills associated with flow lines and shut-in operations. The idea would be to fund this project by the end of July of 2026. But the bigger question or the bigger issue is really a concluding disbursement of roughly $2.7 million from the Martinez Irwin Fund into the Orphan Wells Mitigation Enterprise Fund. As a reminder, that Mitigation Enterprise Fund exists to fund the plugging of orphan wells and remediation and reclamation of orphan sites. This fund is typically funded through a fee paid by industry in conjunction with claimed financial assurance and federal funds. And with these funds, the ECMC Orphan Well Program oversees contractors performing the plugging, remediation, and reclamation work necessary to meet Colorado's requirements for plugging and abandonment of wells and reclamation and remediation of oil and gas locations or sites. While we first focus, of course, on holding operators responsible in the event there's an unwilling or unable operator, we do proceed with orphaning that the entirety of that operator's oil and gas assets in the state and proceeding with, again, the plugging and abandonment of the wells, remediation and reclamation of the sites. So at this moment in time, I do believe the best use of the remaining funds is to continue to drive the plugging of orphan wells and remediation and reclamation of orphan sites in Colorado. Again, that's about $2.7 million available. And what I would ask the commission support for, which Kerr-McGee has also supported, is that the Martinez Irwin Fund will first fund the efforts I described earlier to mediate resolution at an amount not to exceed $15,000, and that will be wrapped up this month. And then provide a disbursement of the remaining unallocated funds estimated at approximately $2.7 million to the Orphan Well Mitigation Enterprise Fund on or before October 1st, 2026. And then we'll work through reconciliation to make sure everybody's numbers match up. And I know that there are a couple of outstanding projects for the Martinez Irwin Fund. Once those are completely funded, we will provide a final payment for the project to Kerr-McGee, sorry, would pay a rebate. Let me start over. After fully funding any remaining approved projects and within 60 days of issuing that final payment, Kerr-McGee would provide a final accounting to ECMC's finance manager and disperse any remaining funds again to the Orphan Well Enterprise Fund. And so with that, I'm happy to take questions. I'd hope for your support and concurrence. And with that support and concurrence, ECMC would also close out the Martinez Irwin Fund, acknowledging that the fund is no longer available for public projects. So with that, Chair, I'm happy to take questions or take further discussion as appropriate.
Thank you. Thank you for the presentation. I just wonder why now? Like, what is driving the idea that we need to close things out now? Is it Kerr-McGee? Is it ourselves? Is it a concern about the Orphan Well Fund? Just general wonder.
Chair, it's a great question. The things that I have been thinking about over the last year is that where and how we've used these funds and with the intent of the Martinez Irwin Fund, which really was to help protect Colorado and citizens from orphaned and abandoned assets. It seems like the creation of this enterprise creates kind of a perfect opportunity to do that. I think that we want to continue to make sure that work is funded as expeditiously as possible. And so this provides flexibility then to ECMC's Orphan Well program to more expeditiously tackle those projects. And so that's what I have been thinking about, is how do we pull that work forward and return surface to surface owners once we complete reclamation and remediation on sites.
Thank you for that. Other questions of the director? Commissioner Ackerman.
Thank you, Mr. Chair, and thank you, Director Murphy. And again, thank you for your service to the state of Colorado for these many years. Hard to have a last hearing with you. I don't like it, but we wish you great luck, of course. Just one question about the accounting of the funds already. Are they currently held in escrow by ECMC, or are they still with Kerr-McGee?
Thank you for the question, Commissioner. The way the fund was designed in 2020 is that Kerr-McGee would hold those funds in escrow, and we have been working alongside of Kerr-McGee since 2020 on reconciliations. We most recently did kind of a more thorough reconciliation in the winter, kind of that of 2025, 2026. So we have a pretty good idea. The number of projects has also kind of requests has tapered, and which gave me some time and space to really think about where best to use these funds. So I hope that answers your question and probably provides a little bit too much detail per usual.
No, that's helpful. Thank you. I appreciate it. And the reason I ask is because I know the fund was intended to move along and had a date by which funds that were unexpended were intended to be moved over to ECMC anyway. And I wondered if that might be a partial answer to the chair's question. The AOC doesn't really talk a whole lot about what to do with those remaining funds once they are transferred over to ECMC, but just wondering what the status of that was, so thank you.
Other questions, thoughts? AAG Pedro, are you with us? Or AAG Davenport, I think you're our lawyer here on this. Just
Yes, that's right, Chair.
have a motion to approve the Martinez Irwin Fund.
I'd suggest a motion to just approve or concur with the plan laid out by the director in the letter that's before you today.
So moved. Do we have a second?
I'll second.
Motion and a second. Are there further deliberations on the motion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? All right. Director Murphy, thank you very much. And again, thank you for all you've done. Now you're going to whoosh away into the distance. Oh, so sad. All right. We will continue with our business. Colorado Parks and Wildlife presentation, 2025 Compensatory Mitigation Report. Dr. Vertura.
Good morning, and to make me follow Director Murphy's farewell is a bit rough, but we're here today to present our 2025 Compensatory Mitigation Report for our 181 funds. This was published back in May, and we're going to present a little bit on what was in the report as well as some of the regional projects. I'll be joined today by our regional seniors. We have Brian McGee for the Southwest region, Andrew Newman in the Northeast region, Taylor Elman in the I'm not going in any order, Northwest region, and Carolyn Crevero Dessat in the Southeast region. 3 of the regions did have funds available this year in 2025 to approve projects, and Carolyn is here in the Southeast to answer any questions at the end if you have on that. Southeast region has not received any compensatory mitigation funds yet from 181 permits. All right, I'm going to share our presentation right now. And can everyone see my slides now?
Not yet.
Okay.
Oh, there we go. Now I see
Okay.
them.
Thank you. So this is, and you've heard quite a bit, or you heard a bit last fall about, this is the Eagle Butte State Wildlife Area that was acquired with 181 funds. And then we'll go through some of the other issues in the report, and again, then leave plenty of time for questions. The CPW 181 mitigation report for 2025 is submitted as an appendix to ECMC's cumulative impact report. So it was published in May. There's a lot of wildlife details and data in the ECMC report as well that was discussed when they presented to you. And so we're going to focus on what CPW did this year in mitigation. The report also contains an overview of the program itself. We've talked about this before to the commission, but it does include background on the report. It does include the general approach of it in the planning, both at the regional planning and prioritization level, committee level, as well as the statewide advisory group and the role of that group. It does talk too about our statewide advisory group, which is consisted of the 5 of us on the call today, as well as representatives of our terrestrial big game, our terrestrial conservation species, our aquatic, and in particular our habitat section. That all has a role in kind of managing the program and oversight. There is also information, again, in the report on previous years, but we're going to try to focus on what was new for 2025. One of the most significant changes, which we're quite proud of, is a new compensatory mitigation conservation easement grant program. This was started in February of 2025. It is a recurring grant program. It is a biannual cycle, which means the program opened in February 2025. The first 6-month grant cycle ended in July 31st, and the awards were made in August. And then immediately a new cycle starts, and the second group of awards were made in February of 2026. We'll talk about those later more specifically, but it is a reimbursement program in support of conservation easements. So we work with land trust agencies, groups and landowners that can apply for reimbursement for closing costs and other management costs of conservation easements. Again, they still have to meet the same criteria. So again, our funding is paid for in with certain permits, and so we target our mitigation in areas that are impacted by that permitted activity, as well as the species and habitats impacted. And so we update the website every 6 months with where we are interested in working with landowners and land trust organizations on conservation easements and what species we're targeting. And I think towards the end, we'll talk about some of those that have gone through. We don't report them until they close because they are a reimbursement grant. So we allocate the funds when those awards are made, but they don't get counted in the program. So in the report, you'll see, I think 2 were in the report because they closed in 2025. Those that close in 2026 will be included in that report. We do think this permanent conservation is a significant benefit to wildlife, and we'll show you some of the numbers as well. And also these partnerships with land trusts and private support for private landowners are a really important component of mitigation and conservation in Colorado. And we think this program is very beneficial for that. And just plug, if there's any land trust organizations watching, the next cycle closes July 31st. This is similar to a chart you saw in the cumulative impacts report. It is the ECMC's permitted disturbance since the new 181 rules went through in 2020. So the first permits approved in 2022. And this is just, this is separated into construction and then road and pipeline construction. And it is, it was highest in 2024 and it has dropped a little bit in 2025. And we do see a pretty good equal spread between like the location, meaning the well pad itself, and then the accessory or associated structures to that. A reminder that permits as they're approved, that is just tracking what has been approved. They do not, if mitigation was part of the assessment in the permit itself and included in the 2A, that is paid just prior to construction. So we have a whole group of permits that have assessed mitigation, but until they're constructed, they do not pay into the mitigation fund. So in 2025 permit activity, there were 23 permits approved with either direct or indirect mitigation assessed. 14 of those locations were in the Northeast, 7 in the Northwest, and then 1 each in the Southwest and Southeast. The direct impacts were just under 600 acres, and the indirect impacts about 1,800 acres. So again, this was what was permitted, and then mitigation payments to CPW for locations constructed in 2025 is a different subset of permits. A lot of those were actually the permits approved in 2024 that constructed in 2025 and paid for their mitigation. So payments made to CPW in 2025, there were 24 locations, 17 in the Northeast, 6 in the Northwest, and 1 in the Southwest. Pretty similar breakdown as to what we saw permitted. Direct impact payments in 2025 were about $1.2 million, and indirect impacts just over $1 million. This shows you where the projects completed in 2025. There were some that were underway, but until we had actually funded them and completed them, we didn't include them in this list. You can see here, as it should, it dovetails with where the oil and gas development is. In this case, green are habitat enhancement projects, meaning habitat treatments, weed spraying, reseeding, things like that. Those are in green, and the circles are scaled to the acreage. And then red are the permanent conservation, in this case, 1 fee title acquisition in the Northeast region, and then conservation easements in the other regions. I think a couple of things here is we do try to find this balance between permanent conservation and habitat enhancement. Habitat enhancement is incredibly important to keeping habitat functional on properties that are already working well for wildlife and providing habitat. Those habitat treatments do often have to be repeated. If we're looking at the life of a well, whether that be 10, 20, 30 years, we aim for at least 30 years, but we try to do more that can be even longer lasting. We do assume that those have to be repeated, and it depends on the treatment, how often we might repeat them. There are also some habitat improvement projects that I think we'll talk about today that may not translate directly to acres, and we do talk about that in the report, but the removal of fence lines are incredibly important for the West, and we are looking at ways to actually how do you translate miles of fence into acres of habitat uplift. And so I think the balance between these is important. The other thing to keep in mind is that it often is extremely expensive to acquire property. And then there is maintenance costs and staffing if CPW owns those properties into the future. So we do try to find a balance so that we can, again, keep conservation on the landscape permanently, but also improve the habitats that we do have. And then this shows you the money spent by CPW in 2025 on mitigation. And this does show you sort of that distinction. So blue is acres, red are dollars. And you can see that the fee title purchase, the one we had this year, it was quite expensive for 630 acres, but we do think it is highly valuable, both for the species it supports, but also for the location. And trying to find available properties where we have oil and gas development can be challenging. Habitat improvement, you can treat a lot more acres for less dollars, again, with the understanding that we're going to have to reinvest likely in the future on some of those province or continue those habitat improvement projects. And then the conservation easement funds is, in that case, those were both part of CPW's new grant program, but also ones that we had worked with landowners and land trust prior to that. So there's a mix in there of both. But I think it does talk about significantly sort of the balance that we're trying to make between permanent conservation and habitat uplift and the benefits of each, and that we think a successful program is going to include both of those. It also we can talk a little bit about the permitting in that we know what has been essentially committed to CPW in those permits, but we don't always know when they're going to get paid. So some of these larger projects, we have to let funds accumulate because they don't always come in on a schedule. Timelines change. Construction timelines are what they are. So this shows you the progress this year in terms of money invested. I will say at the end of 2025, we were spending basically October 2024 dollars. So we had said really a 2 to 3 year window for getting some of these funds into these permanent conservation projects. And I think we're hitting that mark pretty well this year, particularly with the amount of funding that was coming in 2025. And now I'm going to pass this to Taylor Elm in the Northwest to talk about some of his projects.
Yeah, thank you, Karen. Hopefully everybody can hear me. Taylor Elm, I'm the Senior Resource Manager for the Northwest, so essentially the Northwest quadrant of the state. 2025 was a pretty busy year and productive for us in the Northwest regarding the implementation of mitigation projects. We closed on 2 permanent conservation easements, and I say we, as Karen mentioned, land trusts and landowners really were doing the majority of the work. CPW was a funder of these projects. But these 2 projects that closed in 2025 totaled 2,745 acres of permanent habitat conservation. And then I say more in the works there because we've actually awarded grant funding through the program that Karen described to an additional 4 projects in the Northwest. These total an additional 2,813 acres. And actually, one of these closed in May of 2026, and the other 3 are scheduled to close either later this summer or this fall of 2026. In addition to that work, we've done several habitat enhancement projects. These have included approximately 500 acres of mechanical mastication work, so brush treatment, pinyon juniper mastication, about 5.5 miles of hazardous fence removal. We partnered with several folks following last year's elk fire in Rio Blanco County on some restoration efforts. This included herbicide treatments and reseeding to restore that habitat that was burned up there. And then also 767 acres of invasive weed treatments within CPW mapped high priority habitat. And then lastly, I wanted to mention something cool that we were able to do in the Northwest is we established a collaboration with CPW's Habitat Partnership Program, which works with private landowners to reduce wildlife conflicts as well as provide um, projects and habitat enhancement for wildlife on private lands. And so we established kind of a programmatic agreement there where some mitigation funds were used as matching funds for private landowners and implemented a handful of projects through that, primarily consisting of wildlife habitat or wildlife friendly fence modifications and water source developments for wildlife and to better distribute livestock grazing across the landscape. So that's kind of a quick recap of what we had going on in the Northwest, and would be happy to answer specific questions at the end here. Thanks, Karen.
Thank you, Taylor. Next, we have the Northeast region and Andrew Newman.
Hi, good morning. Can you see me? Can you hear me?
Yes.
Okay. Thank you very much, Taylor. Thank you, commissioners, for the time this morning. Yeah, I'll just touch briefly on our highlighted projects in the Northeast region for 2025. As you are aware of the Eagle Butte State Wildlife Area acquisition in 2025, we did present on that last fall. This property is an amazing property in Weld County, 632 acres of high priority habitat for pronghorn, mule deer, golden eagle, and plain sharp-tailed grouse. The geography is great for this property. I can say that the eagle's nest that is located on the property has been productive for several decades, and in the last 2 years since we've owned the property, it has continued to be productive. I was just out there last week checking on the nest, and there were a couple juveniles working on fledging. Currently, we're finalizing our management plan for the property and working on some ongoing habitat enhancement efforts at the site. And those include removing unnecessary fencing, modifying other fencing to be wildlife friendly, and we're looking into some potential water improvements for wildlife habitat there as well. On the habitat enhancement side, in our region, we treated over 2,100 acres for invasive grasses and noxious weeds, focusing on cheatgrass infestations at the Tamarack Ranch. We recognize that these treatments are highly important for mule deer habitat, with some of the recent literature that's come out indicating that mule deer use of habitat declines as cheatgrass densities increase. And so we've been trying to stay on top of that at the Tamarack Ranch. I've been really successful there. We're currently conducting post-treatment monitoring for the treatments, and we'll have year-end monitoring reports for that treatment program in development later this year. This is a project in partnership with our CPW Grasslands program, the Mule Deer Foundation, and INVU. We have several other projects in the pipeline for this year, and I'm excited to present on those next year when we see you again. That covers our region, and I'll hand it over to Brian for our Southwest.
Good morning, commissioners. Brian McGee, Colorado Parks and Wildlife, based down in the San Juan Basin, primarily in Southwest Colorado. Similar to what Taylor's been working on in the Northwest, we did 3 conservation easements in 2025, totaling about 1,100 acres. We partnered with the local land trust here in La Plata County called La Plata Open Space Conservancy to hold those easements. CPW is a funder with the mitigation monies. I think what's been quite significant with this program is we've been able to use the SB 181 compensatory mitigation money to leverage a lot of other investments from partners, specifically like Keep It Colorado, in terms of putting more private land into conservation. So that's been a really good positive outcome of having these funds available to support conservation on the landscape and support conservation where the impacts are occurring. Commissioner Robbins will know this because this is his home turf, but the San Juan Basin has a lot of challenges in terms of land use. And so when we asked our biologists and district wildlife managers what the priorities were for the San Juan Basin in terms of habitat, it was resounding. We need to protect what we have. And so we're super thankful that our EMT and our director supported the creation of this grant fund for transaction costs. And we're small but mighty. We don't spend a ton of money, but we have conserved a ton of acres collectively statewide, and so we hope to continue that onto the future. In addition, we've done in 2025, we're on phase 3 of a multi-year habitat improvement project on a property that has an existing conservation easement on. And actually, that property was put in conservation easement under the 1298 rules through BP's San Juan Basin Mitigation Plan. And so it's continuing efforts over, we're approaching almost 20 years of working on this stuff. So with that, I'll turn it back to Karen.
Thank you. That is the end. Just sort of to summarize, in 2025, utilizing the 181 mitigation funds, CPW invested about $1.6 million in conservation in the state of Colorado as part of the program. We have allocated about another $175,000 to these grants that will be paid out in 2026. And we leveraged over $500,000 in partner funding, a lot of it on those habitat treatment projects. That's not counting all of the other contributions to the conservation easements that CPW is a part of, both from the landowner and the land trust. So we do think 2025 was a big success. Again, knowing that getting the program developed the right way with our planning and prioritization, as well as just the funding mechanisms within CPW that allow us to do things like this conservation grant program in an efficient manner and get money out on the landscape more quickly and supporting our conservation partners. So with that, we can open it up for questions, and happy to discuss any of the projects or any other questions you might have.
Thank you very much for the presentation. It's really helpful, and I think it's really helpful to inform our various stakeholders of the work in this area. Questions for the panel? Commissioner Ackerman?
Thank you, and thank you for the presentation, and not just for the presentation, but for the partnering work that you're doing on this program. One quick question on the Northeast, and then a couple of global questions. And to Mr. Newman, we saw 2 quite large projects that you worked on in 2025. We've seen some smaller projects in the past. Were these these 2 large projects the sole recipient of funds in 2025, or were there other smaller projects? If so, is this kind of an example of this concept of amalgamating funds over years to fund larger type projects that we can expect in the future? Sorry, kind of a multi-part question.
Yeah, no problem. Thank you, Commissioner, for the questions. Yes, these do represent the 2 projects that we did disperse funds for in 2025 in the region. That being said, we have several other ongoing potential projects in the pipeline. And so a lot of these things take multiple months, if not years, to develop and finalize and close on. And yeah, we do have an overarching objective of allocating the funding equally across, fee title acquisitions, easements, and habitat enhancements. And we recognize that we've been successful in acquiring these highly valuable habitat properties like Eagle Butte, and we've had discussed a few others. Those do take time to bring to fruition and close. We are focusing on other opportunities for habitat enhancement in the region. I'm sure, as you're aware, our region is dominated by private land, and so we always have to find willing landowners who are interested in working with us in developing habitat enhancement projects. I will say we have a number of those in the pipeline, and we're hoping to get those into the ground here in late 2025 or early 2026. Did I answer all of your questions there?
Thank you. I'll try to keep them more linear in the future. I appreciate that.
If I can add one little piece to that, there were some ongoing projects that were funded, I think, in 2024 that continued in 2025. But the way we report, if we don't spend that money in 2025, we haven't included it in the report. So I think there was some work that had been funded in 2024 that continued into 25, but if we didn't spend new money, it was not necessarily included as a 2025 project, if that makes sense.
That does make sense, and thank you. It kind of leads into my next point of line of questioning. And, I know this has been very significant work for CPW to set up the relatively complex compensatory mitigation program and its various, and as we've heard this year, kind of increasing components. I, for one, appreciate very much the administrative work on the back end of setting this up to get money on the ground. The discussions at mission change rulemakings kind of contemplated a ramp up of funding expenditures. It looks like we're kind of starting to see that now that we're getting substantive projects on the ground on a bit of a consistent basis here. Have we reached an equilibrium on that issue, and should we expect to see kind of this consistent larger project expenditure going forward?
I think that's going to depend a little on as sources come in. And we talked about the lag between permitting and kind of assessment of the mitigation impacts and then payment. So part of it depends on how much money comes in from what is being drilled in 2026. So I think that whether that drops off, how we can keep up with it, we're still looking at that 2 to 3 year window. We want money coming in as sooner the better. But again, we had committed to a 2 to 3 year window to get that money spent. I do think having the architecture of the program in terms of, I think at the beginning we couldn't even deposit a check, and so I think having the accounting tracking, having these grant programs where we can get money on the ground faster, as well as better understanding of what our available like property might be in terms of that. I don't know if we're certainly going to try to keep up the pace, but it's going to also have to be paced a little bit by incoming, like what permits are paying in 2026. And any of the other regions can chime in, but I do know a lot of those, if operators have kind of, it really depends on timeline and construction schedule. So Taylor, if you want to chime in, or Brian, in terms of what we're seeing, but some construction has dropped off. And that would mean less money coming in, even though those permits have been approved and assessed. So it kind of depends on that part of it too.
Yeah, Karen, I could add a little bit perspective from the Northwest region. Commissioner Ackerman, we actually had a super successful year in 2025 and rolling into 2026. We've spent down our accumulated funds significantly, and we have not, as Karen mentioned, had not had a lot of new funding being deposited in 2026. And so I think, just like Karen said, it's going to depend for us, but we may actually have a bit of a lag towards the end of 26 and going into 27 until we actually kind of accumulate more. But that's kind of maybe unique to our perspective and maybe different across the regions.
Thank you, Mr. Elm and Dr. Voltura. And so what I took from that, and I certainly understand the dynamism of the money coming in, but it sounds like the administrative procedures are largely in place at the CPW side to handle things as they do come in, ramp up as they do, and ramp down as they don't. So I appreciate that. And I'm excited about your easement grant program here where you're soliciting applications. I think that's an appropriate use of money and has been demonstrated to be a significant part of conservation. From your presentation, I saw that you've this year conserved, together with partners, nearly 4,000 acres of permanent conservation easements, which is something at least that I had envisioned when we were talking about this originally. Getting $1.5 million on the ground with upwards of $500,000 more in leverage funds from other partners and landowners also, I think, is an important part of what we're doing here in order to continue to leverage funds for further conservation. And to me, this is more of a statement than a question, but I'm seeing that this program really is providing real benefits to wildlife on the ground through your efforts and those of others, and appreciate the work here. The whole intent of the compensatory mitigation program is to address impacts associated with development as near as possible as we can to the area and species that are impacted. And just wanted to say that I appreciate how much work this has been. I'm excited about the process going forward and the procedures that you put in place. So thanks for the presentation here today.
Thanks, Commissioner Ackerman. Others with questions for the panel? Commissioner Messner?
Thanks, and appreciate the presentation. It really is exciting to see this program evolve since the inception of it after the mission change rulemaking, and it's clear that the utilization of the funds on the ground is starting to make some pretty significant impacts, beneficial impacts, and so appreciate that. One question that I had is out of curiosity is there any kind of coordination or collaboration between the funds that are being developed and utilized as part of SB 24230, I think, and the mitigation funds that we're talking about here today?
Not directly. I think these funds are earmarked for the permitted disturbance. So when we get funds for this program, they're linked to a certain permit. And so it's not that we have to, but we have a certain region they need to be spent in and to benefit certain species as part of this program. The 230 program is more broadly addressed in terms of especially around historic oil and gas impacts. So these are impacts that are not covered really by the current mitigation program through the 181 through ECMC. So I could see a situation where we have the opportunity to use ours as matching funds or those as matching funds if the same project met the same goals. But I think there are much stricter sideboards that CPW has set for the 181 funding because it is tied to permitted disturbance and permitted impacts. And so we are trying to very narrowly focus that. We do, again, have a little flexibility in our program for areas like if something is, that adjacent benefits the same herd, but we are staying to try very local to where that current oil and gas development that funded those projects is. Whereas 230, it is more landscape level. It is more either historic or climate impacts, more landscape connectivity. So I think the projects, there's a much broader application of them, and they don't have some of the limitations that we've placed on these funds for good reason. And if any of our other teammates want to add to that, but we're not seeing any overlap right now, not ruling it out if there was a project where we thought there was synergy, but really the 181 funds are targeting that permitted disturbance area.
Great. Thank you for all your work.
Others with questions? All right, seeing no further questions, we really want to thank the panel for the presentation. It's been excellent.
Thank you. Have a good morning.
All right, let's take a few minutes before we pick up the next matter, which is an oil and gas development plan. It is 9:42. Let's return at 9:50. All right, we are back on the record. This is the Energy and Carbon Management Commission. We're taking up docket 251-200-269, an oil and gas development plan by Noble Energy. It's called the Longhorn OGDP. Mr. Kavanaugh, I see you're here, but I've got a process question before we potentially hear from you. So, Ms. Jost, if you could recognize yourself. My understanding is that there was an additional supplemental practicability assessment, which Ms. Jost, you suggested to staff that it not be attached as part of the 2A, and staff has not analyzed it. And my understanding, and correct me if I'm wrong, is that this supplemental practicability assessment is not part of the record because it's not been attached to the 2A. It doesn't have staff's assessment of it. And the only way commissioners are aware of it is that it was emailed to us in the last couple of days. And so I would like your perspective on that and your perspective on why it is that I should not continue this to get staff to provide some assessment of it and give the world an opportunity to understand that it's part of the record. You're up, Ms. Jost.
Yeah, thank you, Chair Robbins. And it's my understanding that this was submitted to staff and that it was reviewed. And if not, that's something that's new to me. For purposes of not having it attached to the Form 2A, Noble was abiding by the staff's former guidance and the current guidance in our view that once completeness occurs, there is no ability to upload any additional information to the OGDP permit, so meaning to the Form 2A, until we have the blessing of the commissioners. And so the reason we have said that we did not want it attached to the Form 2A is we are abiding by prior ECMC staff guidance. We do have this information in our ECMC hearing presentation that's been submitted in front of you for a week. We're prepared to testify to it in addition today, as well as, if we needed to go into any executive session regarding any confidential business information questions that you as the commissioners may have for us, we're happy to do that. But we do not believe a continuance is necessary here because, again, Noble was just following the ECMC staff guidance that once completeness has occurred, we're not able to upload anything or attach the Form 2A without the commissioner's blessings. So, Chair, we'd like to proceed today and present this to you. We have a very detailed testimony ready to be presented by Ms. Patricia Meinrich on the practicability assessment, the original submission, as well as the requested information from staff as part of the supplemental practicability assessment that, again, we believe staff has reviewed.
All right. The emails I've received is staff has not reviewed this at the request of Noble. Um, Assuming that is the case, and I'm not trying to say what you're saying is not accurate, but there's maybe two versions of a story. I would err on the essence of being cautioned by suggesting that we should continue it and give staff a chance to review the information. I think this is, and I know we're all trying to deal with practicability assessments and we're trying to figure out the right method forward and the goalposts are moving, and I apologize for all of that. But one of the things that I suggested in the practicability assessment guidance was that there should be opportunities to amend the original practicability assessment after it was originally filed, because through consultations with CDPHE or CPW or other, you may come up with more information. And we're trying to get to the best information analysis for OGDP review. So with that, I'll give you one more chance to position your case.
Yeah, thank you, Chair. And I appreciate this. From the standpoint of Noble's perspective, this supplemental information was submitted at the request of staff, and it was to be submitted to be reviewed and just not to be attached based upon that completeness. I think in this instance with the Longhorn OGDP, this OGDP was filed in December of 2025. So it was filed prior to the original practicability assessment guidance. It was obviously filed prior to the time the commissioners started scrutinizing practicability assessments, and it was filed prior to the time of your endorsement of last week's practicability assessment guidance. We would like to present to you today. We think that the information we have in our testimony is very cohesive, specifically with respect to the supplemental practicability assessment. This OGDP has been pending for a while. We think that the testimony will actually be very helpful for you as the commissioners because we address the post submission, meaning the post practicability assessment submission information with respect to electrification for the drilling unit or the drilling rig, as well as the permanent production facilities. And we also have a director's recommendation for approval on this based upon the information provided that actually references the supplemental practicability assessment that was submitted. And so we would like to proceed today, and we've prepared kind of with this in mind, Chair. This OGDP application is ripe for hearing.
All right. I've been informed by staff that they actually did review it, but that review is not incorporated into the director's recommendation.
Right.
So again, I'm like, oh, what does that give me? Not a whole lot. I mean, like if they reviewed it, but I don't have their analysis of the review, it doesn't provide me as one commissioner that perspective. But I've talked too much. Other commissioners with thoughts about how we should process through this. I do note, I'm just looking at the operational timeline. If we move through this today, construction stage starts in the Q4 of 2026. Drilling is in Q1 of 2027. Completions is in Q2 of 2028. So it seems like there's still a little time to allow for that analysis to be developed, but that's just me talking. Other commissioners with thoughts? Commissioner Messner?
Thanks, Mr. Chair. I mean, I think, at least for me, it's important that staff is utilizing um, the supplemental the supplemental practicability assessment in development of the director's recommendation. And while I'm not clear, it's still not clear to me whether they have or they have not reviewed the updated practicability assessment or the supplemental practicability assessment. And I don't see anything in the director's recommendation that indicates that they have utilized the supplemental practicability assessment within their analysis of, within the director's recommendation. In fact, I don't see a lot in the director's recommendation even referencing, in any type of detail, the practicability assessment in general, which is, as I indicated during our discussions around practicability assessments, ultimately is a really important part for me in determining whether or not an applicant has fully met the rules of as they review the application. And so I also am cognizant that, we're still working through some of this. My biggest challenge is that I received this supplemental practicability assessment yesterday afternoon. And so that I struggle with being able to evaluate all of that and apply it, in that short a time, but I don't know if that's the applicant's fault. So I'm comfortable moving forward. If we want to move forward, I do acknowledge that this has not been incorporated in the director's recommendation. So I'm not sure what kind of, record issue that brings up as far as whether or not a full record has been reviewed by staff in development of the director's recommendation.
All right. My understanding is that staff reviewed it, but they did not incorporate it into their director's recommendation, and that we received it as of yesterday. I'm still inclined to continue. Others with thoughts? Ms. Jost, I see you've unmuted. Go ahead.
Thank you, Chair. And I appreciate this discussion. I think that, just for purposes of making the record, I don't think this is right for a continuance. I think this is right to go today. But at the time this application was filed, this guidance was not in place. You guys just endorsed this guidance last week. We are all trying to work through it. Chair, I know you just mentioned moving the goalposts, and that's exactly what's happening here. That practicability of the supplemental information was submitted to staff on June 22nd. So staff has had this. It is not the applicant's issue if they did not incorporate it into the director's recommendation, and it was submitted to the commissioners yesterday. We have been ready to go on this OGDP, and we are ready to address that information that was provided in the practicability assessment originally, as well as the supplemental practicability assessment and our detailed hearing presentation today. We have heard you, we have listened, we have lessons from all of our prior OGDPs, and we are ready to present this today. I think the other thing I would say is this commission has said on several occasions that they're not specifically tied to everything in the director's recommendations, and you guys can make your own independent analysis. And so we would request that we present today, and if you believe that there's still additional work from staff to incorporate the supplemental practicability assessment that was not required by a guidance or rule later in the hearing, and you decide to continue, I think that's something a bridge we could cross, but we would really like to present this to you today. Thank you, Chair, for that opportunity.
All right. Thank you. Let's take 5 minutes and give staff an opportunity to collect their thoughts. I'd like to hear from someone from staff on this issue because the way I'm reading it is Noble specifically requested staff not to include an analysis of this. And so I'm hearing two different things, and I just want to clear the record. So we will return at 10:08. Just FYI, staff needs a couple more minutes, so let's give them that time. We'll return at 10:11. All right, we will reconvene on project 251200269. And the direction from the panel had been that we would like to hear from staff about the supplemental practicability assessment. Good morning, Ms. Mercer-Gilman.
Good morning, Mr. Chair and the Commission. Thank you for giving me a few minutes there to chat with our staff and make sure I had an understanding of the situation before coming to talk to you. So I'm going to back up a little bit and share what I've learned about this supplemental practicability assessment. So the timeline is that Noble submitted the supplemental practicability assessment to staff on June 22nd. Staff was finalizing the director's recommendation at that time, which was published on June 25th. I've been told that when the supplemental information was submitted, staff's understanding was that Noble requested that not be added to the Form 2A, that it would be something that they would present on at hearing and then could be added to the application file after hearing. And so based on that conversation, staff went ahead and published the director's recommendation without including anything on the supplemental assessment. It sounds like there was perhaps misunderstanding or a disconnect between staff and the applicant with respect to when staff sort of locks down an application and can't accept anything additional on it. So post-completeness, staff is still, can still take additional information and incorporate it into the DR, the director's recommendation. It's typically after the director's recommendation that staff considers that application locked and ready to go to the commission and doesn't like to accept anything new unless directed by the commission. So that sounds like that was perhaps a miscommunication. I think, this is obviously a unique situation as to the practicability assessment, but to me, it strikes me as not entirely different from situations where we'll have an operator come to hearing and present additional information that wasn't part of the application previously, new BMPs they'd have decided to commit to, or additional context around what they are and aren't doing. That is something that it's been this commission's practice, I think, to accept that kind of information at hearing. The bottom line is staff has reviewed the supplemental practicability assessment. It was not considered part of the application based on conversations with the applicant, and so it wasn't addressed in the director's recommendation. In terms of whether this commission, whether staff needs to do anything additional here or before the commission can hear it, staff's view is that the additional practicability information wouldn't change the director's recommendation. So staff does not feel, we don't feel a need to go back and add anything unless, of course, that's the commission's wishes. So happy to answer any questions that you might have.
Okay, thank you, Ms. Mercer-Gilman. Appreciate that perspective. I'm just trying to make sure we got a good record here and that we're taking things up in the right vein. And I do recognize that we're all working hard to make sure that the practicability assessment is done consistent with the rule, et cetera. And I don't want to feel like I'm wishy-washy, but if what I heard from staff, it sounds to me like we could probably move forward. If after we hear from the applicant, we still feel like there's a need for some additional staff assessment, maybe we can ask for it at that point in time. But I'm talking too much once again. Other commissioners with thoughts on this whole situation? Commissioner Oath?
Thanks, Mr. Chair. I don't think you're talking too much at all. I appreciate us all trying to work through this. Appreciate Ms. Mercer-Goman's comments. I think the one thing for me that is perhaps a little different or a bit of a loose thread here is that part of the discussion we had recently around looking for some analysis from staff on the practicability assessment information. And so I understand what Ms. Mercer-Gelman is saying in terms of staff not feeling that this would change the ultimate DR and maybe, what the recommendation is, but that analysis is still not there. I'm not saying I'm not willing to move forward, but I guess just as we're thinking about how we're approaching these going forward, that is, that's still a piece that I think would be missing if we move forward in this situation. And I think we can work with that. Just wanted to make that comment.
Others with thoughts, comments? All right, seeing none, I suppose let's hear the OGDP, and then we'll make a determination on whether we're ready to make a decision once we've heard from the relevant parties. So with that, and after 25 minutes of discussion, I would bring back Mr. Kavanaugh from Weld County to understand Weld County's perspective on this OGDP. Welcome.
Thank you, Chair, and thank you, Commissioners, for continuing this. Are you able to hear me okay?
Yeah.
Perfect. Well, good morning, and thank you for the opportunity to briefly address the Weld County WOGLA process for Noble's Longhorn Oil and Gas Development Plan. This OGDP contains 3 locations under Weld County's permitting jurisdiction. The OJED department held a pre-application meeting on October 1st, 2025 with OJED staff, Noble staff, ECMC, and Weld County planning staff in attendance. The 1041 WOGLA application was received on January 19th, 2026. No interventions were submitted for Apollo or Yellow Jacket locations. OJED received 1 application for intervention pertaining to the rampage from the city and county of Broomfield. In the application, Broomfield stated no objections, but rather a desire to be able to participate in the hearing due to horizontal wells potentially going under property owned by Broomfield. The hearing officer granted Broomfield intervention status. Broomfield raised no concerns at the hearing. The 1041 WOGLA hearing for all 3 locations was held on April 2nd, 2026, and the applications were approved by the hearing officer. The final orders were recorded within Weld County Clerk and Recorder and noticed in the Greeley Tribune on April 22nd, 2026. Creating a vested property right pursuant to Article 68 of Title 24. The approved 1041 WOGLA permits incorporated Noble's commitments to best management practices as outlined in the application, protect public health, safety, welfare, the environment, and wildlife of Weld County. The permits are valid for 3 years, during which construction must commence unless the extension is approved. Because the 1041 WOGLA process is complete and the final orders have been issued, recorded, and published, the Weld County has no concerns with the pending ECMC permit and recommends approval. And that's all I got.
Thank you, Mr. Kavanaugh. Again, always appreciate Weld County's perspective. Thanks for taking time out of your day to provide that to us.
Thank you.
Local government perspective is an important component to OGDP review. Are there questions for Mr. Kavanaugh? All right, seeing none, we'll let you get back to your busy schedule. Ms. Jost, next, as you're well aware, is the raising of witnesses and the swearing in of witnesses. Let's have everybody visualize themselves that's planning on talking. Mr. Boudreau will do the swearing in.
Wonderful. Thank you, Chair. And Mr. Boudreau, we have everyone on.
Great. I'll ask each of the witnesses to be visualized When I call your name, please raise your hand, state your first and last name, and swear to tell the truth. Patricia Minerick,
Trisha Meinrich, I swear to tell the truth.
Brian DeRose,
Brian DeRose, I swear to tell the truth.
Mike Keller,
Michael Keller, I swear to tell the truth.
Dawn Lane,
Dawn Lang, I swear to tell the truth.
Seth Even,
Seth Even, I swear to tell the truth.
Laura Gramadsky,
Laura Gramadsky, I swear to tell the truth.
Tyler Blessing.
Tyler Blessing, I swear to tell the truth.
Did I get everyone, Ms. Jose?
You did, Mr. Boudreau. Thank you so much.
Thank you.
All right, Ms. Jose, the video floor is yours.
Wonderful. Thank you. I'm going to start sharing my screen, Chair. And Chair, can you just confirm that you can see that in full screen?
We can see that in full screen and we can hear and see you. Thank you.
Wonderful. Thank you so much. Well, good morning, commissioners, council, staff, and the listening public. My name is Jamie Jose of Jose Energy Law, and along with my partner, Kelsey Wazelinski, we represent Noble Energy, Inc. and the Longhorn OGDP application before you today in docket number 2512-00269. We'd like to thank the ECMC staff and the director for their efforts on this OGDP, as well as Weld County for their processing of Noble's WOGLA permits to approval and vested right recording. We'd also like to thank CPW and CDPHE for their communications with Noble on this development plan. This slide illustrates the topics we will be discussing today, and I'd like to start by summarizing the Longhorn OGDP application and the requested relief before I turn the presentation over to the Noble team. The Longhorn OGDP was filed on December 22nd, 2025, and obtained completeness from ECMC staff on April 8th, 2026. The Longhorn OGDP requests that the Commission approve the approximate 9,120 acre OGDP for the development of up to 75 horizontal wells from 2 new surface locations and 1 amended existing location within the proposed OGDP, to establish 5 drilling and spacing units for the development and operation of the Niobrara, Fort Hays, Greenhorn, and Graneros formations, and approve 3 Form 2As, 1 for the Apollo State G1111 pad, the Rampage State G1414 multi-pad, and the Yellow Jacket G23-12 pad. The Longhorn OGDP is located in Weld County, and as we know, Weld is the relevant local government. All 3 locations have received approved WOGLAs from Weld County, and those WOGLAs have been recorded, thereby creating vested rights, and there's no proximate local governments. This OGDP triggers a Rule 304 alternative location analysis due to 7 residential building units within 2,000 feet of the proposed oil and gas locations. Noble has obtained informed consent from each of the 7 residential building unit owners and their tenants. None of the proposed locations are in high priority habitat or in a disproportionately impacted community. Noble analyzed 10 alternative locations for the 3 oil and gas locations in the Longhorn OGDP, which you will hear about in detail today. In review of each of the alternative locations, they were either closer to residential building units, Noble could not acquire surface use agreements, or the location was not as protective as the 3 proposed locations. Staff reviewed the cumulative impacts analysis, the ALA narratives, and the ALA data sheets that Noble had attached to the Form 2As, and staff and the director support the 3 proposed locations as part of the Longhorn OGDP. Also, as part of the Longhorn OGDP, Noble has firmly committed to several best management practices that will serve to avoid and minimize and mitigate potential adverse impacts. Some of these best management practices include, but are not limited to, utilizing Tier 4 or natural gas engines. Oil, gas, and produced water takeaway will be in place from the date of first production. Utilization of a tankless hydrocarbon storage facility, use of Group 3 drilling mud, and only 1 occupation for each well pad. As required by Rule 316C4D, Noble submitted a practicability assessment with the December 2025 OGDP submittal, which is attached to the Form 2As. This assessment was submitted prior to the issuance of the January 2026 ECMC staff practicability assessment guidance and prior to the time the commissioners started to inquire about submitted practicability assessments. The Longhorn practicability assessment was required because Noble is not able to apply the 2 following specific enhanced systems and practices at the time of filing and remains unable to do so as of the date of this hearing. The first enhanced systems and practices found in Rule 316C4C, Romanet 1, which provides that the operator will use grid power or on-site solar power for all permanent powered production equipment on-site, excluding external combustion sources. And the second ESP rule is Rule 316C4C, Romanet 2, that provides all drill rig engines and or turbines with a manufacturer's design rate greater than or equal to 50 horsepower will be powered by grid power or non-fossil fuel generated power. Noble will present direct and distinct testimony on the Longhorn Rule 316 practicability assessment today, and will discuss the continuous efforts made to obtain grid power from the utility provider without disclosing confidential business information between Noble and that utility provider. To be upfront on the current issues surrounding the noted ESPs, Noble wants to ensure the commission that it respects the commissioner's requests for documentation of those communications, but Noble, however, remains committed to ensuring the integrity of the confidential business negotiation process with the respective utility provider and the importance of keeping confidential negotiations private, and has prepared today's presentation to reflect each of these factors. Noble's exhibits B1 through B5 to the Longhorn OGDP application are the drilling and spacing unit applications for the Apollo State Drilling and Spacing Unit, the Apollo Greenhorn Drilling and Spacing Unit, the Rampage State Drilling and Spacing Unit, the Yellow Jacket Drilling and Spacing Unit, and the Yellow Jacket Greenhorn Drilling and Spacing Unit. The Apollo State Unit will have up to 27 horizontal wells. The Apollo Greenhorn Unit will have 1 horizontal well. The Rampage State Unit will have up to 23 horizontal wells. The Yellow Jacket Unit will also have up to 23 horizontal wells. And the Yellow Jacket Greenhorn Unit will have at least 1 horizontal well. Noble owns and has secured the consent of more than 45% of the leasehold interest in each unit, and Rule 505 land, geology, and engineering testimony has been submitted to support each unit. Noble has complied with all notice requirements for the Longhorn OGDP. No formal petitions were filed, and no public comments were received. Noble did obtain a director's recommendation for approval of the Longhorn OGDP on June 25th, 2026. And the director's recommendation confirms Noble's compliance with all applicable ECMC rules and the Energy and Carbon Management Act. As discussed earlier today, we would like to note that the director's recommendation stated, and I quote, on June 24th, 2026, which should have been June 22nd, 2026, Noble provided a document entitled Enhanced Systems and Practices, Not Practicable Practicability Assessment Additional Information. Noble has declined to have this document included in the Form 2As. Despite staff's request, Noble has not provided correspondence between them and the local power authority, end quote. The reason for Noble's specific declining to attach the June 24th document to the Form 2A is because the ECMC rules and prior staff precedent do not allow an operator to submit any documentation on the Form 2A after completeness has occurred without starting an OGDP over. And they also do not require that the operator submit confidential business information, communications between themselves and a third-party utility provider as part of the Rule 316 practicability assessment. Also as addressed, the ECMC staff request for the third-party confidential business information to be attached to the Form 2A was premature in light of the Commissioner's recent July 8th, just last week, 2026 endorsement of the updated ECMC practicability assessment guidance. Notwithstanding Noble's decision to not attach the June 24th information to the Form 2A, Noble will present certain of the information today during the hearing, and if necessary, based upon Commissioner questions, will request an executive session to address any Commissioner questions regarding confidential third-party business information requested by staff or the Commissioners. Noble respectfully requests that the Commission approve the Longhorn OGDP application, the 5 corresponding drilling and spacing unit applications, and the 3 Form 2As. Noble is in compliance with all applicable ECMC rules and the Act and looks forward to presenting this approvable application to you this morning. With that, I'd like to go ahead and turn it over to Ms. Patricia Meinrich from Noble to continue the presentation.
Thank you.
Thank you, Jamie, and thank you, Commissioners, for your time. The operational timeline shown here indicates the earliest estimated dates for commencing operations. The earliest construction phase for the Apollo pad and the Yellow Jacket pad is estimated for the fourth quarter of 2026, with the earliest estimated Rampage multi construction in the third quarter of 2027. The earliest drilling phase for the Apollo pad and the Yellow Jacket pad is estimated for the first quarter of 2027, with the earliest estimated Rampage multi drilling in the fourth quarter of 2027. The earliest completions phase for the Apollo pad is the second quarter of 2028, with the earliest estimate for the Rampage multi in the third quarter of 2028, and the Yellow Jacket pad is estimated for the fourth quarter of 2027. The earliest interim reclamation phase for the Apollo pad is the fourth quarter of 2028, with the Rampage multi estimated for the first quarter of 2029, and the Yellow Jacket pad is estimated for the second quarter of 2028. As part of our Longhorn OGDP, we have conducted the pre-application meeting and we have received local government approval. The pre-application meeting was held on October 1st, 2025, with representatives from Weld County and ECMC in attendance. Although CPW was not in attendance, they submitted an email requesting sound walls on the north side of the Apollo pad if construction occurs between December 1st and April 30th, and for the drainage from the Yellow Jacket to be directed away from the adjacent HPH native aquatic species, which has been accommodated in our design plans. At the conclusion of the pre-app meeting, Noble received the green light to submit the Longhorn OGDP application with the standard area of evaluation for the Rampage multi and Yellow Jacket pad, and Noble agreed to expand the area of evaluation for the Apollo pad to encompass the Easton Valley View Airport. The proposed locations for the Longhorn OGDP are outside of any disproportionately impacted community pursuant to Colorado EnviroScreen version 2.0. I will now hand the presentation to my colleague Brian DeRose to discuss the siting and alternative location analysis that went into the Longhorn OGDP.
Thank you.
Thanks, Patricia, and good morning, commissioners. For this portion of the presentation, I'll walk through Noble's alternate location analysis and explain why the three proposed locations were ultimately selected as the preferred and least potentially impactful sites for developing the Longhorn OGDP. I'll begin with a brief overview of the pre-application meeting held on October 1st, 2025, hosted by Weld County and ECMC. As a part of that process, Noble evaluated 10 alternate locations in addition to the three proposed locations before you today. On the map, the alternate locations are shown in orange and the proposed locations are shown in green. During the pre-application discussion, the agencies agreed that the three proposed locations meet the intent of both ECMC rules and Weld County Code for oil and gas development. Noble did not receive any objections to move forward with the Longhorn OGDP application and committed to providing the detailed alternate location analysis we are reviewing today. As shown here, surface location options in this area are very limited, especially locations more than 2,000 feet from existing residential building units. Even with those constraints, Noble was able to secure three critical surface use agreements for locations that reduce potential impacts to public health, safety, welfare, the environment, and wildlife resources. We'll start with the Apollo State location and the unit, which would develop the northern portion of the Longhorn OGDP. The proposed pad is shown as an orange box on the map, and the three alternate locations evaluated for this area are shown in blue. Starting with alternate location 1, the surface owner for this pad was unwilling to execute a surface use agreement. This site is also significantly further from proposed centralized tank battery and would require 10 additional acres of surface disturbance to connect to the centralized production facility for the project. Excuse me. Alternate location 2 has 3 RBUs within 2,000 feet. Noble did pursue and execute a surface use agreement for this location. However, further evaluation showed that impacts to wetlands would be significant compared to the proposed location. And this site is also within a high priority mule deer winter range. And based on those factors, Noble decided not to pursue this location for development. Alternate location 3 has 5 RBUs within 2,000 feet. Noble evaluated a potential site with a surface owner, but the surface owner was unwilling to enter into a surface use agreement. This location is also within high priority habitat for aquatic native species. After completing the assessment of the alternate locations for the northern portion of the Longhorn OGDP, Noble concluded that the proposed Apollo State location is the preferred and least impactful location to developing this part of the project. On this slide, I'll highlight the key characteristics of the proposed Apollo State location and why those characteristics support moving forward with this site as preferred location for the proposed mineral development unit. The Apollo State well pad is located on rangeland pasture, so it will not impact current or future farming operations on the property. The location is more than 1 mile from schools, child care centers, and other high occupancy building units. The topography allows Noble to consolidate the oil and gas development from footprint, and the site is outside of high priority habitat, NSO areas, wetlands, and floodplain. It is also centrally located within the unit, which supports efficient drilling and completions activities. Noble has executed a surface use agreement and has a surface use agreement in place for this location. There are 4 RBUs within 2,000 feet of this location, and Noble has obtained informed consent from each owner and tenants associated with the RBUs. It is also worth noting that the 2 of the 4 residents are owned by the same surface owner, whose property includes the proposed location. Next, we'll move into the Rampage State Unit, which would develop the central portion of the Longhorn OGDP. The proposed location is outlined in orange, and the alternate locations are shown in blue. For alternate location 1, the surface owner was not open to entering into a surface use agreement, and the site is also within 2,000 feet of 7 RBUs and could create impacts to high priority aquatic habitat. Alternate location 2 has an active surface use agreement, and Noble initially considered using it as a well pad while keeping the proposed Rampage location as a facility only. However, that approach would add another surface location and increase overall community impacts. If this alternate were developed as a multi-well pad, it would affect more than 5 RBUs and the proposed location, and would create greater impacts to high priority habitats because of the larger footprint required. On this slide, we'll take a closer look at the proposed Rampage State multi-location, which would serve both as a facility and as a well pad using Noble's tankless design. The location is outside high priority habitat, wetlands, and floodplain, and Noble has executed a surface use agreement with the landowner. An informed consent has been obtained for the 2 RBUs within 2,000 feet. The location also allows Noble to use an existing facility footprint and existing access off of County Road 44. It aligns well with the other 2 proposed locations in the OGDP for flow line routing, and the site is primarily located on pasture ground with a small portion within cropland. We'll now move to the third and final proposed location within the Longhorn OGDP, which is planned to develop the southernmost portion of the project. The proposed Yellow Jacket location is shown in orange, and the 5 alternate locations are outlined in blue. In reviewing the Yellow Jacket alternates, Noble found similar challenges across the locations. The surface owners were not interested in executing surface use agreements, largely due to concerns about impacts to current and future farming operations. In addition, alternates 1 through 4 had more RBUs within 2,000 feet than the proposed Yellow Jacket pad. These locations would also require longer flowline routes to the Rampage facility, increasing overall surface disturbance. Based on this review, Noble determined that the proposed Yellow Jacket location is the least impactful option for public health, safety, welfare, environment, and wildlife resources. For the proposed Yellow Jacket location, the evaluation comes down to a few key factors specific to the southern portion of the project. When compared to the alternate locations, this site provides the best overall balance of landowner agreement, operational efficiency, and reduced potential impacts. The Yellow Jacket pad is located primarily on rangeland with a portion on irrigated cropland. This layout limits impacts to current and future farming operations, and the site is also more than 1 mile from schools, child care centers, and other high occupancy building units. From a development standpoint, the topography allows Noble to consolidate the oil and gas footprint, and the site was designed to avoid high priority habitat, NSO areas, wetlands, and floodplain. It is also well positioned to work with the Rampage site for facility consolidation, and Noble has executed a surface use agreement for this location. Finally, there is one RBU within 2,000 feet of this location, and that resident is also the surface owner of the Yellow Jacket location. Noble has obtained informed consent from the owner. And with that, I'll shift it over to community outreach efforts conducted for the Longhorn OGDP.
Thank you.
As a part of the permitting process, Noble held 2 community meetings for the Longhorn OGDP. The first meeting was held on November 3rd, 2025. The second meeting was held on May 13th, 2026. Common questions during those meetings focused on haul routes and road usage, proximity of proposed locations to residents, product takeaway, operational scheduling, and legacy well removal. Overall, the attendees expressed support for the proposed locations and for the Longhorn OGDP as a whole. Noble recognizes community outreach as both an important part of Colorado permitting process and a key component of our social license to operate in the DJ Basin. For the Longhorn OGDP, outreach efforts to date have included several key steps. First, Noble distributed informational packets to owners and tenants of each RBU. Second, Noble sent invitations to 2 community meetings and engaged a total of 28 stakeholders. Third, pre-application notices and hearing notices were all sent to owners within 2,000 feet of the proposed locations. Finally, Noble provided direct points of contact, met individually with residents along haul routes, and made our community call line, email, and website available for questions and concerns. As with all Noble locations, outreach will continue throughout the life cycle of these projects. Noble will continue to maintain the 24/7 non-emergency community call line to address questions and concerns. We will also send activity notices for each phase of the operations associated with the Longhorn OGDP to all residents within 2,000 feet of each location. In addition, Noble will continue to hold in-person meetings upon request with residents, local governments, and emergency response agencies. With that, I'll turn it back over to Patricia to discuss the wildlife environmental assessment for the Longhorn OGDP.
Thank you, Brian. The proposed locations for the Longhorn OGDP avoid siting within HPH. The access roads and pipeline corridor for the proposed locations are also outside of high priority habitat. CPW did request that sound walls be installed on the north side of the Apollo pad if construction occurs between December 1st and April 30th. Due to nearby mule deer severe winter range, Noble has designed all of the proposed locations, including the Apollo State pad, to feature sound walls. CPW also requested that the drainage for the Yellow Jacket pad be directed away from the adjacent HPH native aquatic species. Noble has designed the Yellow Jacket pad with an infiltration pond that will avoid offsite drainage and potential impacts to the nearby native aquatic species HPH. CPW has granted the Rule 1202A3 waivers for the ordinary high water mark. Additionally, as part of the Longhorn OGDP development, approximately 16.5 acres of high priority habitat will be reclaimed. To complement our minimization and mitigation efforts for wildlife, the Longhorn OGDP also includes efforts to minimize and mitigate impacts to air quality, odor, light, noise, water, and land. Design features of the Longhorn OGDP incorporate a number of best management practices, BMPs, and enhanced systems and practices, ESPs, to protect the public health, safety, welfare, environment, and wildlife. To avoid and minimize impacts related to odor and air quality for Longhorn OGDP, we will use a centralized and tankless hydrocarbon storage facility located at the Rampage Multi. Drilling activities will use Tier 4 or natural gas engines and Group 3 oil-based mud. We will use pipeline infrastructure for oil, gas, and water takeaway, thereby eliminating truck hauling. Drill cuttings will not be stockpiled on location. To avoid and minimize impacts from light and noise, well pad locations will feature sound walls during pre-production activities, and sound impact analysis has been conducted to produce sound models. Quiet frac fleet will also be used to reduce potential noise impacts during completion operations. Lighting will be directed inward and downward with no permanent lighting on well pads. Where lighting is needed, LED fixtures are used to minimize sky glow and reduce off-site visibility. The images on the top model a location with noise mitigations without noise mitigations and with mitigations during drilling operations. The images on the bottom model a location without noise mitigations and with mitigations during completions operations. As you can see from the color coding, noise levels just outside of a mitigated location with sound walls is comparable to a conversation. To avoid and minimize impacts to water and land, the Longhorn OGDP will feature a facility with tankless hydrocarbon storage and pipeline takeaway. Noble will utilize erosion and sedimentation controls through segregated and stockpiled topsoil retained for reseeding. CPW has granted the Rule 1202A3 waiver for the proposed locations for chemical storage within 500 feet of the ordinary high water mark. All locations will have automated monitoring 24/7 through our Integrated Operations Center, allowing early detection of issues and reducing the need for on-site traffic. We will also use advanced leak detection systems, including SCADA, infrared cameras for identifying leaks, smoke, or fire, while enhancing site security and feature remote shut-in capabilities. Drilling and completion operations will feature a guard shack at the access road to manage site entry and support overall safety. To summarize our enhanced systems and practices under Rule 316C for the Longhorn OGDP, Noble understands nearly all ESPs under Rule 316C2 and 3 to be applicable and plans to comply with them as required. Some of the highlights are as follows. Tier 4 diesel or natural gas drilling rigs in accordance with Reg 7, natural gas-fired completions engines, pipeline takeaway for gas, oil, and water, and a tankless facility design. The ESPs for drilling and facility electrification are understood to apply to this OGDP, and Noble is working with the utility provider to make grid power available to the locations. However, at the time of submittal of the application, Noble determined through a practicability assessment that it was not practicable to comply with these two ESPs. While adequate power is now estimated to occur in the region, current grid infrastructure still does not support the proposed locations. Upgrades are required. The utility provider determines the construction schedule for upgrades. While we can make requests and we can help negotiate easements, ultimately, the upgrades are beyond Noble's control. Additionally, even once the infrastructure is in place, the utility provider cannot guarantee the required power quality or reliable availability for our location's needs to operate all of the equipment all of the time on grid power. We are attempting to electrify the locations of the OGDP, and if successful, we will use the power available to us to minimize emissions, but that may not rise to the very high level of these two ESPs. Noble first started engaging with the utility providers for this OGDP in December 2023. While our practicability assessment has not changed from submission, we have engaged in continuous efforts with the utility providers, even after initial discussions indicated that existing infrastructure did not support the project. However, at the time of this hearing, we anticipate that the utility provider will likely be able to provide electrification to power the production facility. Once again, the delivery of power, its quality, and its reliability are beyond our control. While progress is ongoing, these upgrades are still beyond Noble's control. Therefore, we cannot commit to a condition of approval that would require electrification of the production facility or operations. We will continue to diligently pursue capacity. Obtaining electrification is advantageous to us as an operator, as it helps support our efforts to continue to meet our NOx and GHG intensity goals, and in anticipation of new air permitting requirements resulting from future redesignation of the ozone non-attainment area to an extreme classification. Utility service to the Longhorn OGDP is also split between providers. Development for a portion of the Longhorn OGDP requires invasion agreements between utility providers. These invasion agreements are once again outside of Noble's control. At the time of this hearing, our understanding is that Excel will be the power provider for the Longhorn OGDP, subject to change of third-party agreements to which we are not a party. As previously mentioned, upgrades to the system infrastructure are required. Since submitting our OGDP application per our recent status update with the utility, they have made progress in the pre-construction design of the needed infrastructure, but construction has not yet started. We do want to reiterate that once infrastructure is in place, the utility provider cannot guarantee the power quality or reliability for our location's needs to operate all equipment all of the time on grid power. Any capacity that we are ultimately able to procure will be directed to the electrification of the permanent production facility. Solar is not a practicable alternative to provide the needed power supply for the rig or the permanent production equipment. The surface disturbance needed to accommodate the solar panels and battery storage is estimated to double or triple the planned surface disturbance for the proposed locations. As part of our Longhorn OGDP, I want to highlight some of the associated beneficial impacts. The Longhorn OGDP footprint demonstrates Noble's efforts to minimize impacts through consolidation and reducing the number of locations necessary to recover the target minerals. Following interim reclamation, the footprint of the proposed locations will be approximately 18 acres out of the 9,120 acre development. Noble will plug approximately 128 wells and remove 46 facilities for an estimated 192 acres reclaimed, including 16.5 acres in HPH, resulting in an approximate 174 acre net benefit. In other words, Noble is reclaiming more than 9 times the acreage than will remain in the long term as part of the Longhorn OGDP. These 128 wells and 46 facilities that we are removing are also within 2,000 feet of 144 RBUs, so we are reducing the impacts to these 144 homes. The plugging and removal of these wells and facilities will also remove the associated emissions, thereby eliminating 6.6 tons of VOC, 48 tons of carbon monoxide, and 1.3 tons of NOx. An estimated 16,000 plus annual vehicle trips will also be eliminated in association with the well and facility plugging and removal. If we were to use solar, we estimate that the surface disturbance to support solar panels and battery storage would increase 144 to 205%. Thank you for your time. I will now turn the presentation back to Jamie Jost of Jost Energy Law for the conclusion and requested relief.
Thank you, Ms. Meinrich. To summarize the Longhorn OGDP and Noble's request for approval, again, we'd like to note the following OGDP highlights. All 7 residential building unit owners and/or tenants have provided informed consent. The locations are not in high priority habitat or a disproportionately impacted community. Noble has presented and staff has reviewed a substantive Rule 315 cumulative impacts analysis and the Rule 316 practicability assessment, the original as well as the supplemental that was submitted on June 22nd. And as you heard earlier this morning, Ms. Mercer-Gelman said that staff had no further comments and it would not have changed the director's recommendation for the additional practicability assessment to be included in that document. Noble will utilize Tier 4 natural gas engines. Will have 3-phase takeaway in place from the date of first production. They will utilize a tankless hydrocarbon storage facility, Group 3 drilling mud, and again, will have only 1 occupation in each well pad. No Rule 507 petitions were filed, and the Weld County WOGA list for each location is approved and recorded as a vested right. The Longhorn OGDP provides substantial protections of public health, safety, welfare, the environment, and wildlife resources by siting outside of sensitive receptors, and the best management practices and applicable ESPs avoid, minimize, and mitigate potential adverse impacts. And finally, the director's recommendation does recommend approval of the Longhorn OGDP and expressly concluded that ECMC staff does not anticipate any significant potential direct adverse impact to public health, safety, welfare, the environment, and wildlife resources. Based on the foregoing presentation, as well as all of the documents in the OGDP submission, Noble respectfully requests that this commission approve the approximate 9,120 acre Longhorn OGDP for the development of up to 75 horizontal wells from 2 new surface locations and 1 amended existing location within the proposed OGDP boundaries, to approve the 5 drilling and spacing units for the development and operation of the Niobrara, Fort Hayes, Greenhorn, and Graneros formation, and approve the 3 Form 2As. With that, I'd like to ask the rest of our panelists to come on video for commissioner questions. And commissioners, thank you again for the discussion earlier for your consideration of this approvable OGDP application.
All right, thank you, Ms. Jost, and to the panelists for the presentation. We now open up the panel for questions from commissioners. And I also would alert Attorney General Benjamin Boudreau to the fact that I would like at some point to hear back from Lauren Mercer Gilman or staff to see if their perception of the OGDP and the director recommendation has changed as a result of the oral testimony given today. Thank you, Ben. Questions? Commissioner Messner.
Thanks for the presentation and the information that was provided. Just a couple of questions. So the first one is about schedule. And so, one of the, I guess, potential issues here with the practicability assessment and the operations is that the ESPs do apply because there's an anticipation that the schedule is required to occur during the ozone non-attainment season. I didn't hear a lot of testimony or evidence in the record indicating why it's necessary to operate during the ozone season, especially since we're not looking at any timing stipulations associated with high priority habitats. And so I'd like to hear some evidence or some testimony, as to the need to be able to operate in the ozone season. I see some of the pads are, at least from a drilling standpoint, are anticipated, I think, to be drilled outside of the ozone season. And so really the ESPs associated with the practicability assessment, at least one of the ESPs in the practicability assessment with electrification of drill rigs wouldn't apply. But then some are being contemplated inside of there. So is it an operational it's an operational issue? Is it a choice issue? Like what is the reason that we have to be in the ozone season for the drilling operation or drilling and completion operation?
Yes, thank you, Commissioner. I'll respond to your question. So we are a 24/7 operator and we do have multiple projects ongoing. Some of those do have timing stipulations. So it's really about balancing our schedule with where we can go. And right now we have met and we are below our NOx intensity targets. So we do anticipate having some portion of this development in the ozone season.
Okay, but whether or not you're in your NOx intensity limits doesn't have anything to do with whether ESPs apply or not, right? And so that was really the question is kind of the operational need to be in the ozone non-attainment area and not having certain ESPs apply. I'm getting to the first point of avoid, minimize, and mitigate, right? So avoid first, then minimize and mitigate. And so just trying to give you an opportunity there. But I think what I'm hearing you say is it just fits better in your schedule.
With all of our other operations, this is where it is currently aligning. Our schedules do change, and a lot of that we're not in control of because there are third parties involved. So right now, we do intend or anticipate operations within the ozone.
Okay, thanks for that. And then the other question that I had was around the supplemental practicability assessment associated with I'm more concerned about the production equipment, the permanent production equipment and the electrification of that and the ESP associated with that. Because I do know that at least on your schedule, as of right now, some of the drilling is being contemplated outside of the ozone non-attainment area. But I've read the supplemental practicability assessment. There's a lot of statements in there that don't have any substantiation. And so help me understand the challenges associated with providing evidence from the utility provider on that.
Yes, thank you. So I will start that our priority is to direct any capacity that we are able to procure to that permanent production equipment. And so that is our first priority. As far as discussions, we have had ongoing communications with the utilities. Further than that, I will have to defer to my counsel as to confidential business information.
Thank you, Ms. Minor. Chair, and then Commissioner Messner, if I may address you in your
Yep.
question.
Please.
Thank you so much. So, Commissioner Messner, I think the evidence term used was one that was in the recently endorsed July 8th, 2026 practicability assessment guidance, which again has not been yet made public. So from the standpoint of Noble's confidential third-party utility provider information that was sought by the staff and we know was sometimes requested by commissioners, that still remains confidential business information as part of negotiations and contracts with a third-party utility provider that's outside of this commission's jurisdiction. And so I appreciate you reviewing the supplemental practicability assessment. I think that's great. It was 8 pages. It was submitted with the intent to provide this additional information that staff and commissioners wanted. But Noble's been very committed to preserving the integrity of those confidential business negotiations with the third-party utility provider, which is why you don't see a communication or an email or documentation attached to that practicability assessment. So I'm hoping that answers a little bit of the question, but as Ms. Meinrich testified to, while the ESPs apply, there is the comma where practicable. And that is where, in this instance, the electrification for the drilling rig as well as permanent production facilities just is not deemed practicable based upon those discussions and information provided by the third-party utility provider, which is well outside of Noble's control and this commission's control.
Thanks. I appreciate your opinion on that matter. There's no further questions. I'll have some thoughts on this in deliberation.
Thank you, Commissioner.
Other questions for the panel? Ackerman beat you by a half a second, Commissioner Oath, so we'll go with Commissioner Ackerman first and then Commissioner Oath.
Sorry, Commissioner Oath, but I'll note that down. One time I beat Commissioner Oath at something, so I appreciate that. My question actually is a bit of a follow-up on Commissioner Messner's questions. And, through the evaluation of this application, I've been trying to figure out the electrification issue, as I'm sure you have been as well. And it's still a little unclear to me what the steps are from here forward. So let's hypothetically say this is approved today. Can you talk to me a little bit about what you expect to do from this point forward to work towards, first, electrification of permanent facilities, and then to fulfill some of the illusions that are made in the, that's illusion with an A, not with an I, some of the illusions that are made in the application to potentially get some power to drill rigs as well? What are the steps forward?
Yes, so as we've done throughout this process since 2023, we will continue to have communications with the utility providers. We will work on any easements that we can to help their process, and we will have regular status updates with them to see where they are at in their process and if there's anything that we can do on our side to help that. We are at their direction, and so that is our current process.
Thanks. So I took from that you'll continue to talk and coordinate.
Yes.
And that makes sense to me for procurement of available power. Is there any path to potential power path upgrades still, or opportunity to dedicate power from that point forward? Or is that just kind of, we'll take it as you got it?
I think we will take it as they have it, obviously, and if there's opportunities for additional upgrades or whatever is needed, we will continue to work with the utility as they direct us.
Thanks, Ms. Meinrich. And I thought I heard you say, and correct me if I'm wrong, but I thought I heard you say in the presentation that it's looking like they'll be able to provide power to the production facility. It was unclear to me if that was limited to the production facility. First of all, make sure that I heard that right. But if that's limited to the production facility, but there's no such tentative commitment to provide ongoing power to any other permanent facilities. Did I interpret that correctly?
So we do anticipate to have some power for the production facility, and that would be the only kind of ongoing permanent operation once it comes on production. The well pads will flow into that production facility. So that is where we're concentrating the power capacity.
Gotcha. And that makes sense to me. And so again, just to verify, and I'm not trying to back you into corner here, but what I'm hearing is that all signs point towards you being able to long-term power the permanent equipment without a firm commitment at this point. Is that correct?
Yes, that is what we are working towards.
Okay. Nothing further from me, Mr. Chair. Thanks.
All right, Commissioner Oath.
Great, thank you. So just a few follow-ups. I guess going back to schedule, I think what I understand from the schedule is that drilling is actually looks like at all three locations would be occurring in quarters 1 and 4, so outside of the ozone season, but completions are anticipated and scheduled for during the ozone season. Is that correct?
I would have to go back through and look on my slides, but I believe that is in line with what we are developing currently. As always, schedules are subject to potential movement.
Yeah, okay. Thanks. And then in terms of kind of the question around availability, thanks for providing some information around quantity needed of power during drilling. I think you indicated 3.5 megawatts of power needed during drilling, but I didn't see, and I don't think we covered in Q&A yet, what you anticipate needing during production.
Thank you, Commissioner. I do not have that information readily available, but I can follow up with you.
Do you believe information that you'd be able to get, if we took a short break at some point, or would it require a longer period of time to provide that?
Yes, I think we should be able to get it with a short break.
Okay. Great, thank you. And then let's see. In thinking about the information you provided around impacts that would occur with the application of the ESP, I think one of the discussion points you raised was, well, even if we were to say, hey, we need to, wait on this project until the necessary upgrades have been made, that sort of the trade-off there is that then there could be more receptors in the area. But I just want to clarify, you're not expecting any development in this area. This is just kind of like a hypothetical that there could be changes.
That is correct. We have designed our operations and our cumulative impacts based off of reasonably foreseeable impacts. And so we are not foreseeing any additional impacts, and delaying operations is not a guarantee of delivering of power capacity or quality. The utility cannot guarantee that now or at a future date. And then I wanted to circle back to your original question. I have received information. So for production operations, we anticipate needing 2 to 2.5 megawatts, which is less than what is required for drilling.
Okay. Yeah, that makes sense. Okay, thank you very much, and appreciate your team behind the scenes giving you that on the assist. So thanks all for the efficiency there. Okay, and then CC is around kind of sort of reductions versus operational challenges. And so in terms of reductions, thanks for the quantification there, anticipating, that we kind of with grid power during drilling, we could expect maybe a reduction of 20% in pre-production NOx emissions. I didn't see anything about estimated reductions during production with the use of grid power versus the engines you're planning to use. Is that information you have or to add, or do you not have that?
I do not have that information available. I could confer with my colleagues offline to see if they have that readily available for you.
Okay. Okay. Let's see. I think that was all of the additional questions that I had. Thanks.
Thanks, Commissioner Oath. Other questions for the panel? Commissioner Cross.
Thank you, Mr. Chair. I just want to try and ask a couple quick questions to try and make sure I'm summarizing what I've heard in response to some of the other questions. So any ability to get electrification will go to the production facilities as opposed to being focused on either drilling or completions, correct?
That is correct. The production facility is a long-term facility, so that's where we are focusing our attention.
And the and the drilling as scheduled would occur outside of the ozone season with the possibility that schedules could be altered some.
Yes, I believe that is correct.
And even if you were to get power, there likely would not be the technology or the power available to potentially complete using electrification, correct?
Correct.
Okay. And then the other thing I wanted to confirm is you said there was 144 homes within, was that within specifically the wells that are going to be plugged and abandoned if this is approved, or wells and facilities?
Yes, so it's 144 homes within 2,000 feet of the wells and facilities that are going to be plugged and reclaimed as part of the OGDP development.
Okay, I think those are my only questions for now. Thank you.
Thank you, Commissioner Cross. Further questions? Commissioner Mercer-Gelman.
Thanks, Mr. Chair. I don't have a question. I was just coming on in response to your question earlier, asking me to reappear to share whether staff changed our views of the application based on the presentation. And the answer is no. The director's recommendation stands as is and is consistent with everything presented today at hearing.
So the director's recommendation is for approval, which was where it was started. And we've received this additional practicability assessment information, and that does not change the director's recommendation, just to create a good record here.
Yes, that's correct. The additional practicability information was really just additional details and context around what staff already knew. So it's appreciated, but it does not change staff's recommendation for approval.
Okay, great. And if we could just step back from this particular application and everyone try to do a good job of acknowledging the existence of the new guidance that's come out and acknowledging that there may be opportunities for practicability assessments to be reinformed with new information. I think that's a great thing for everybody. So I just want to put a pin on that. So having said that, I will stop deliberating outside of the context of this one particular OGDP, and I will ask if there are any further questions of commissioners to the panel. Seeing none, we move to deliberations. Ask the panelists to unvisualize, and I can see everybody better. And then commissioners, does anyone desire to start deliberations? Commissioner Metzger?
So a few different thoughts. Like for me, the application is well done. I do see a lot of benefits from the 128 wells being plugged. I do see, a a valiant attempt at the alternative location analysis, the ability to get informed consent from all of the different RBUs inside of 2,000 feet. I mean, a lot of this stuff is, relatively standard and well done application that I think we're used to seeing from this applicant. And so I really appreciate that. Where I'm struggling a little bit is with the practicability assessment and the ESPs and the applicability of ESPs. And so two different pieces there that I think are important. And I'll start by stating that I've been asking for evidence associated with not only practicability assessments, but a number of submittals that have been provided by applicants for years now, right? And it's no different in this particular situation where I'm asking for evidence associated with a practicability assessment, which I've also consistently done since the implementation of the enhanced systems and practices. And the reason that I ask for this is for this Rule 517, which is the applicability of Colorado court rules and administrative notice, which indicates that, in general, the Colorado rules of evidence applicable before a trial court without a jury will be applicable in matters before the commission, providing that such rules may be relaxed, whereby doing so the ends of justice will be better served. Well, in my opinion, in this particular situation and in situations before the commission, the ends of justice are not better served by not requiring evidence in submittals like a practicability assessment, where statements stating something, which in the rules of evidence could be considered hearsay, without it being substantiated somehow. Which is why in land use in general, when submittals are provided, there is some substantiation of those submittals, and there's lots of different ways to do that don't include lists of emails or private correspondence that's gone on between an applicant and a third party. And so that is where I will continue to struggle, and I struggle with this one, is that there has not been a substantiated evidence associated with statements that were made in a practicability assessment. And so I'm not sure that that does meet the rules. And so I'm not sure that that is, I'm just not sure that that meets the rules. And the enhanced systems and practices, as I've indicated before, is a required element from statute and the act. It's not something that we decided to do because we feel like it. It's actually a required part of our rules in the act. And so I struggle with that one a little bit. I also think that there's a clear opportunity for the drilling aspect of this, and the need to place a practicability assessment for an enhanced systems and practices might be unnecessary, because it does appear that drilling, as anticipated right now, can be scheduled outside of the ozone non-attainment area. So therefore, the requirement for utilization of electrical drill rigs wouldn't be applicable. And to me, that's the best scenario. That's the easiest way to meet the rule, is to not have the rule apply to you. And it doesn't appear that that is outside of reasonableness to see that happening, or have a condition of approval that be that they not drill inside the ozone non-attainment area. Now, if there were conflicting high priority habitats or other things that would really create scheduling issues other than the operator's general schedule, then I think that there would be other considerations associated with that. But it does seem reasonable to without those other timing stipulations, to have that drilling happen outside of the ozone non-attainment season. So in the end, those are my two issues with an otherwise really well done application. But in trying to apply the rules as I think they were intended by the act and by statute, I'm struggling with the permanent production facility piece and the non-substantiation of the statements that were being made in the practicability assessment. And I would like to see a condition of approval that would remove that drilling outside of the ozone non-attainment area, which would alleviate my concern with the practicability assessment and the not substantiated statements in the practicability assessment associated with drill rigs and electrification of those. On another note, I know that this operator does indicate that it will try to get it, and I think we've seen evidence that they will try to get it in other circumstances. I've also, been in this role long enough to see that there are situations where they have indicated that they will try to get it, that they were unable to get it. And so that lack of certainty, also feeds into my decision making. So those are my initial thoughts, Mr. Chair.
Thank you again for leading off, Commissioner Messner. Other initial thoughts from commissioners? Commissioner Ackerman.
Thank you. I'm happy to jump in as well here. Commissioner Messner said it well. I wanted to emphasize that the work done by Noble, in my opinion, is generally exceptional, and I don't find this application to be any different outside of the points that we're contending. I think that they've taken every opportunity to use the best practice possible in all other aspects of the application. I specifically wanted to point out, there's a number of things, but I specifically wanted to point out the commitment to plug 128 wells. It's a net decrease of 174 impacted acres and the removal of 46 facilities that are approximate to 144 homes, as was testified to today. This is a very large reduction in emissions that's certainly playing into my thoughts on this application and weighing the pros and cons and the benefits of approving this application as opposed to moving forward with further opportunities to work on the 2 points from the ESPs. I think what I'm seeing here is a effort by the company to do their best to work within the constraints of available utility power. I'm a little uncomfortable with kind of the lack of real concrete commitments going forward, other than just, we'll work with them, see how it goes, see what they got available. That makes it difficult for me. I think a best practice would be enumerating a plan forward in some detail as to what that means, and even maybe with a condition of approval to put forth best efforts moving forward on that front. I would agree with Commissioner Messner that the only hangup that I have on this application is associated with these points. I get a lot more comfortable with this type of an application if there is a commitment to power all permanent production facilities with grid power going forward. I think that is doable in lots of cases, and it seems to me with a concrete plan could be doable here, and it seems to me that there's at least a tentative plan that it is soft commitment doable. I think that electrified drill rigs definitely are a huge temporary draw on the grid, and I recognize that that's a lot more of a complex environment, and recognize that they're committing to do what they can there. And I also recognize that postponement of the project is likely to just provide the same challenges going forward. And so it's a bit of a conundrum for me here as well, because on one hand, I think the benefits of this application going forward are significant. I think that there have been best case commitments throughout the application. And with a little more, to me, a little more acquiescence in best efforts going forward and what those look like, I could get more comfortable with it. To Commissioner Messner's point, the one point that's difficult for me is not a significant effort to move drilling outside of the ozone season, as he's pointed out. I think that's the one point where there is something significantly within Noble's control that granted is not convenient and offers up other difficulties. But to my knowledge, from the documents that I've reviewed, wasn't significantly explored. I think that's an avenue for further exploration. So those are my thoughts at this point. Thanks, Mr. Chair.
Thank you, Commissioner Ackerman. I tend to agree. I appreciate the thoughtfulness of the application, the 128 wells that are going to be plugged, etc. I tend to think that the conditional approval of best efforts makes some sense, and would look to my fellow commissioners for further deliberative thoughts. Commissioner Cross.
Thank you, Mr. Chair. Part of the reason I wanted to ask the clarifying questions that I did is I think it's consistent with what Commissioner Ackerman was just saying in terms of getting a little more comfortable with the production facilities, because I do think that that's one of the things that long term that's going to continue to have the beneficial impact as opposed to the short draw on the grid system that he described. And understanding that the power required for the production facilities is going to be less than even that short draw and the drilling that's required as well. So I do think in what we're seeing and hearing from the practicability assessment is genuine efforts to continue to work with Excel to make sure that the production facilities, as power comes in, they're going to do it. And I think that's probably the most key thing to me. One of the things that I find interesting is that even part of the concern is getting enough power even for the production facilities, let alone getting enough power for the drilling and completions. And so I think that one of the interesting things from this application is it, at least from an outsider's perspective, appears that Chevron realizes that and is taking efforts to try and make sure that the drilling is going to occur outside the ozone season, but they're not willing to commit to drilling outside the ozone season in case something does change with the schedule. And I understand schedules can be very hard, and I understand there already may be commitments that they have to make sure they're outside of the ozone season in other situations. I like the idea of something with the best efforts to ensure that that doesn't happen. Maybe if for some reason the schedule is going to change, that they come before us and let us know, something like that. Because ultimately, I think what we're seeing here is a thorough application. As Commissioner Messner said, there's a lot of good things in it. Reducing 128 wells, 46 facilities, significant decreases in surface use, especially given that those reduction in wells and facilities is within such a close proximity to so many RBUs currently. The informed consent, the stakeholder outreach, I think all these are very, very good things. And I think that what we're seeing, especially as we're trying to get a better grasp of what we talked about with respect to the practicability assessment after our hearing last week, but seeing that supplemental information coming in, continuing to look at what we as a commission are hoping to garner from practicability assessments, but also in as much information as possible being provided to staff, so staff can also provide recommendations as well. I think that the supplemental information provided is quite helpful. I do understand and appreciate Commissioner Messner's concerns with the substantiation factors, and I think that it did appear that there would be a willingness to at least have an executive session to discuss those. And so I think if there is a genuine concern about that, I think we could try and go to an executive session and try and discuss that, is the feeling that I got from the information that was submitted. But I think ultimately what it comes down for me is seeing a lot of information provided about we are meeting the ESPs for the most part. There are a couple we're trying to do. We're trying to get the production facilities, and we're seeing consistent efforts to work with Excel, consistent efforts to say, we obviously know that we cannot control the timing of when infrastructure is going to come in, but we'll take the power as it comes. And a continued commitment to that, I think, is important. And again, I think when it comes to the drilling aspect of things, I think it's something that, given that they're already struggling to get the power supply necessary for production facility, the idea of trying to get the power supply necessary for the drilling, especially on the shorter time frame, is going to be almost certainly out of hand. And so seeing that the at least proposed schedule is outside the ozone season, I think is important for that connection to that part of the ESP. Again, I would be amenable to looking for some best faith efforts to try and make sure that they keep that schedule outside the ozone season, because I think that would also clear up a lot of things as well. But I think overall, to me, some of the beneficial impacts from current infrastructure that's out there with respect to wells and facilities and the reduction of those wells and facilities, I think is quite noteworthy, as well as the informed consent. But those are kind of my initial thoughts.
Thank you, Commissioner Cross. Commissioner Oath, did you raise your hand?
I did, but really, Mr. Chair, just to say, don't know that I have anything else that I need to add at this point. My thoughts are more or less similar to what has been stated, and so I think I'll reserve additional comment until maybe we explore the conversation around COA.
All right. Further comments, further exploration around COA? Commissioner Messner?
Thanks. I think, and maybe we've had this interpretation before, but I can't remember. But I wonder if AAG Boudreaux could talk a little bit about what does best efforts mean from a legal standpoint?
So,
wait a minute.
sorry,
I'm just going to give you a little pause. That's a tricky question.
I don't mean to make it tricky. I'm trying to understand, like, what my understanding is that best efforts meant something legally, but I can't remember what it is, and so I'm just trying to remember. Because
I gave you a little leeway, AAG Boudreaux. Now go for it.
Thanks, Mr. Chair. As best I understand it, best efforts is a requirement for operators to make an earnest attempt to do whatever it is that the COA is requiring. Having said that, from an enforceability standpoint, best efforts is difficult to enforce for any number of reasons.
I think it's like a super duper commitment to do everything you can to get something done, and then trying to litigate whether you super duper did it maybe is difficult. How's that for a layman's perspective?
I think that's probably accurate, Mr. Chair.
Okay. Thank you for answering my question. I think that I guess from my opinion, the best efforts associated with the electrification of production equipment, what I do think is the most important element here from a long-term impact perspective. I'm comfortable. I would be comfortable with the COA on that. That would include best efforts. I think from a drill rig standpoint, I don't think that there is a best effort that can be done associated with the drill rigs, because it does, at least from the testimony that has been provided, and the statements that were made in the practicability assessment, it doesn't appear that electrification of drill rigs is going to be possible. However, it does seem like in applying the mitigation hierarchy, it is possible to avoid the need to even have that ESP apply in these particular situations. And so my suggestion would be to have a condition of approval that would require drilling to be outside of the ozone non-attainment area, or if they were to drill in the ozone non-attainment area, to have it electrified. But as they're proposing it to be outside of the ozone non-attainment season, then to memorialize that with a condition of approval that they will drill outside of the ozone non-attainment season. And then from the permanent production facility electrification ESP, I think a best effort COA is appropriate in my opinion. So I'll kick that off.
Thanks for the deliberative thoughts and the question of AG Boudreau. Others with thoughts, comments, deliberations, motion. Mr. Messner, do you want to make a motion?
I will stumble through a motion, sure.
All right, AG Boudreau, keep your ears up.
So I will move approval of the application with two conditions of approval. The first conditions of approval is that all drilling operations occur outside of the ozone non-attainment season. And the second condition of approval would be that best efforts will be made to electrify all permanent production equipment associated with the sites included in the OGDP.
Okay, we have a motion. I want to see if we have a second before we move to discussion and or an opportunity to check in with operator on this.
I'll second that motion.
All right, we have a second. Ms. Jost, thank you for continuing to be with us. Would like to, not that we have to have consent, but we try to work through these things in a manner that is productive for the commission, operators, and staff, and our stakeholders. And in that vein, I would like to hear any comments now, or I can give you a 5-minute break to chat with your client.
So I can provide some upfront comments, Chair, and I guess based upon feedback from that, I may ask for a break with my client, if that's okay. For purposes of the proposed condition of approval to utilize best efforts to obtain power for the permanent production facilities, Noble will agree to that COA. For purposes of the COA to commit to drilling outside the ozone season, Noble cannot commit to that COA. That will, as this commission knows, and will impact every other OGDP development plan and schedule and timing that Chevron has on its books. That would impact the movement of drilling and completions for other OGDPs, which would put those drilling and completions timing in high priority habitat. Some of those are in disproportionately impacted communities. We also are utilizing Tier 4 rigs with a natural gas engine that's fully compliant with Reg 7. And so drilling during ozone season should be allowed. The Form 2D has been approved for this season. It would likely be approved for next season because Noble is basically over compliant, more than the 20%. And so, Chair Robbins, I really respect the ability to have this last part of this meaningful discussion with the commission, because to require Noble to have drilling operations as a commitment of a COA on this OGDP outside of ozone season, it will result in impacts to other OGDPs, residential building units, high priority habitats, and DIC for other plans. And so that's just something we need to make sure this commission is well understanding of. So thank you.
So the motion as stands, I think what I'm hearing would create cumulative impacts to other approved or applied for Chevron activities.
Correct.
Is that accurate?
That is very accurate.
Okay. Commissioner, yeah, and there's no fault for us having an opportunity to have dialogue back and forth here. We have a motion on the table, but we've not acted on it. So, Commissioner Messner, would love to hear your dialogue on that point, or whatever point you think is relevant.
Yeah, I mean, I appreciate this opportunity. I find it odd that in submittal materials in a hearing that there's a proposed calendar or a schedule that includes all operations for drilling occurring, not completions, but drilling outside of the ozone non-attainment area or season. But somehow with a condition of approval following the schedule that's being proposed by Noble, it's going to, for certain, affect every single other operation that Chevron has. And so to me, that's a little odd that you would propose a schedule at hearing that now you're saying would cause adverse cumulative impacts associated with all other Chevron activities.
Yeah, Commissioner Messner, Chair, if I may.
Yes, please.
Thank you, Commissioner Messner. I appreciate that. The schedule shows the start dates of the entire duration. These are estimates. I think, as we well know, the estimates are required by your Form 2A rules and your Form 2B rules. Those are estimates, and that's exactly why we cannot commit to drilling outside of ozone season. One, because they are estimates, and two, there is an impact. When looked at this from the overall basis of Chevron's OGDPs that are either permitted, pending, or soon to be permitted, hopefully, by this commission, it does have an impact. And so, again, those are estimates as required by your rules and required by the Form 2B. So that is really, in my view, in compliance with your rules. It shouldn't be odd. It's what's drafted, it's what's submitted, it's what was put in the presentation. What was put in the presentation matches the dates on the Form 2B, and that's what's carried through for the hearing presentation. And there are impacts to any movement of any schedule, as we all know. Thank you.
Commissioner Cross?
Thank you, Chair. I'll be honest, as I was contemplating the best efforts, I was also contemplating the best efforts with respect to the drilling. And I think in large part because of the discussion we're having right now. I think it at least, again, from an outsider's perspective, appears the applicant said we can't electrify drilling, so we should try and stick outside the ozone season, and that's why it's planned as such. Also with the understanding that there could be problems. There could be problems with the previous site use of the drilling. There could be problems with the drilling as it occurs at the time. And if everything starts to get shifted by 2 or 3 weeks, it starts to bleed into. And that's why I also made the comment during my deliberative thoughts that maybe we include some kind of discussion of if it is going to bleed over into the ozone season, then they need to come and talk to us and let us know. Because I do think that if that continues to push, obviously we know from prior applications that Chevron is using highline powered drilling rigs at certain times where available. And we also know that they're trying to make sure that certain drilling that can be, or that has to be done in those situations is going to be during the ozone season, is where available is going to be happening with that. But at least my perspective from looking at the application is there is already the attempt based on those estimates to stay outside of the ozone season, understanding that it could change. That's where my idea behind the best efforts came in, was to try and make sure that they were going to be making every effort possible, or potentially coming to talk to us if they can't meet that expectation with respect to drilling outside the ozone season.
Chair, if I may.
Please.
Thank you. With respect to the best efforts applicability for purposes of drilling and production, I do believe that's something that Noble would be open to.
Okay.
Thank you.
With those comments, Commissioner Messner, you have a motion on the table that's been seconded by Commissioner Oath. Do you want to move forward with your motion? Do you want to amend the motion, given what we've heard from the applicant? What are your thoughts? Sorry to put you on the spike here, but
Well, I'm less interested in the applicant's responses and more interested in other commissioners' responses, because I could modify it. I have some concerns, and I have some concerns for specific reasons, right? So I've been on the commission long enough that, I started as a volunteer commissioner when this applicant, um, you know, went through a comprehensive development plan with the Wells Ranch and, had pages in an application where they talked about how electrification of the Wells Ranch was going to be, the primary driver and why that would made so much sense to do a comprehensive development plan. And so, as part of a condition of approval, associated with that or part of the order, it talked about, they were going to provide an electrification plan and they were going to show how it was going to, be built out in the electrification of that comprehensive development plan. And then in the end, when the first applications came in, the electrification plan consisted of informing the commission that we're not going to be able to electrify. And so I have some concerns with what best effort means in application, when I think, at least the way I read the statute and the act, that, some of these things need to be implemented or they need to be avoided. And so I think that's where I struggle a little bit with best efforts. And so I think they're close enough with the production facility electrification that I'm comfortable with the best effort concept there. I think with the drill rig piece, I don't think best efforts to electrify the drill rigs makes sense because it doesn't seem like they're going to be able to electrify the drill rigs there. And so in lieu of that, I think there is an option to move it outside of the ozone non-attainment season. I think there's also paths forward that if schedules cause problems and they need to come in and ask for a variance, then they can do that, if the schedules aren't going to allow them to meet that condition of approval. But those are my thoughts, but I'd like to hear from the other commissioners before I start modifying the
yeah,
motion.
that's fair. Commissioner Oath?
Thanks for this. I guess, bottom line, where I am is that I think I really appreciate where we are with best efforts on using grid power for permanent production equipment. I think that everything we've talked about makes sense. I think there will likely be some grid power, and I do believe that this operator will make best efforts to prioritize the use of any grid power that's made available to them for purposes of powering production equipment. I think in this case for the drilling rig and the idea of a COA that is best efforts to conduct drilling activities outside ozone season, I think I can be comfortable with, and I think it's because overall, as I think about the information provided in the practicability assessment, the strongest element that I think we received was the information provided under EE, right, about what are the other things that this operator is doing with this application and at this site to sort of help with the trade-offs of emission reductions that we're not getting with the designed ESP, but what are we getting in other ways? And I do think that the Tier 4 engineer round is a piece there. I think the tankless design is a piece there. And the biggest piece there is the significant number of older wells that are going to be plugged under the proposal. And so I can get to a place where I'd be comfortable with a COA of best efforts on both.
Thank you, Commissioner Oath, and I agree, and not to equivocate with other commissioners that may want to have thoughts about this, but I think that and we've also had some discussions around cumulative impacts, and like I think maybe this is part of that discussion is cumulative impacts of current and potential future oil and gas wells. And I think this is where if we impose something on this well, the cumulative impacts analysis can create a negative situation on other wells. And I think that's a valid point for the commission's consideration. Commissioner Cross, Commissioner Ackerman, any thoughts on this? Commissioner Ackerman.
Yeah, just I think Commissioner Oath articulated my thoughts really well. Something that's swaying me is that the best efforts have been demonstrated so far by at least planning the drilling phase outside of the ozone season. I certainly understand Commissioner Messner's points of view that if that's when they're proposed, well, let's solidify it. I would be comfortable for that reason with a continued best efforts post-approval to keep those outside of the ozone season. And cumulatively, I think that, to me, demonstrates compliance with continued best efforts to do everything that we can to reduce cumulative impacts.
Anything else, Commissioner Cross?
No other thoughts.
So hearing the other commissioners' thoughts, I'll rescind my motion.
Okay. And then with that, AG Boudreau, you're a lawyer, so I'm able to put you on the spot, but could you potentially capture the thoughts of the collective commission around a motion, and then one of us can say, so moved?
Sure. So to clarify, it sounds like the commission has coalesced around two conditions of approval. One is best efforts for the operator to conduct drilling operations outside of the May 1st through September 30th ozone non-attainment season. And the second is best efforts to electrify all permanent production equipment and the sites associated with the OGDP. Did I get that right, Commissioner Messner?
Yes.
He says tentatively.
Sorry. I'd like to know whether they were successful or not, right? And so I think to me that ends up being a really important part of this best efforts is some sort of reporting to the commission on whether or not they've achieved what they're making best efforts towards or not, because I think that helps us understand kind of what that means when we make these kind of conditions of approval. Success rate, I guess.
And I think that's fair. And AAG, I was going to call you Commissioner Boudreau, but AAG Boudreau, I think having a reporting element is something that is consistent with some of the case law that we've developed to ensure that the commission is comfortable with what efforts were made, whether success was achieved, and if not, what happened to negate success. So I would ask that we add that to the motion, which is what I think Commissioner Messner was also asking.
That being the case, might I have 5 minutes to talk with staff about how to phrase that COA so that the reporting aspect is consistent with previous COAs?
Yep. And that gives Attorney Ms. Jost an opportunity to speak with her client as well. We'll return at noon.
One last thing, Mr. Chair, just to put everyone on notice. When I make my recommendation, I'm also going to recommend that the what we're calling the supplemental practicability assessment be attached to the 2A so that it becomes part of the record.
Yeah, that makes sense. Ms. Jost, do you have a problem with that?
We do not. Thank you, Chair.
All right. Let's return at noon. Now it's 4 minutes away. All right, welcome back, Energy and Carbon Management Commission. We are continuing our discussion on the OGTP before us. We had taken a break to let staff have a chance to think about conditions of approval as well as the operator. So let's hear from staff first.
Do you mean me, Mr. Chair?
Yep, I do.
So I spoke with staff briefly. The conditions of approval that we came up with are, number one, operator will employ best efforts to conduct drilling operations outside the May 1st through September 30th ozone non-attainment season, and will utilize grid power if technically feasible for drilling operations if operations occur during the ozone non-attainment season. Operator will provide an update on the status of the operator's efforts to comply with this condition of approval. And number two is operator will use best efforts to electrify all permanent production equipment and the sites associated with the OGDP. And then I would also recommend that the commission direct ECMC staff to attach the supplemental practicability assessment submitted by the applicant on June 22nd, 2026 to the Form 2A. And that would all be part of a motion to approve the application.
Okay. Let's give the operator, not that we have to, but we're trying to all work together. Let's give the operator a couple of minutes to think through that language. It's a little bit different, I think, than what we had originally envisioned, although I think it's accurate. So, Ms. Jost, can I give you a couple of minutes to chat with your client about that?
Yeah, Chair, and if I may direct a question, Mr. Boudreau.
Yeah.
Mr. Boudreau, is there any way I could see that? That was a lot of additional words what I thought the COA was. Is there a way, or maybe I could just have a call with you or
Email it to
something?
you.
Okay, we email it. Thank you. So, Mr. Chair,
Okay.
can we have 5 minutes, please?
Yep.
Okay.
We're at 12:07. Thanks.
Wonderful. Thank you. Thank you, Mr. Boudreau.
All right, we are returning. I think we should hear from Ms. Jost.
Thank you, Chair. I would love to be able to wait for Mr. Boudreau, if that's okay.
Yeah. I
Okay.
think he's here. He just hasn't visualized yet. All right, there he is.
Mr. Boudreau, I did send you a very quick email back. Noble would agree to the condition of approval with one change of term, and that is the term technically feasible. That term is no longer used in statute or in rule. That was done away with in Senate Bill 19-181 and in our mission change rulemaking. So we would turn technically feasible into where practicable to reflect Rule 316. Everything else we would agree to.
What about where reasonable and necessary? That was the change in the statute.
I think where practicable sits with the rule better, Rule 316. But I think where reasonable and necessary would likely work.
A.G. Boudreau, throwing you on the bus here, but do you have thoughts?
As between where practicable or where reasonable and necessary?
Or anything else? You're a lawyer. Help us out.
I think either one works. It's a best efforts COA. So there's certainly some prudence in adding where practicable since that's part of the rule. That's a standard that the commission both currently employs and staff is familiar with. So I think that can work fine. And as I said, this is a best efforts COA. So enforceability is, the I don't think this is changing where practicable to where reasonable and necessary really impacts the ability to enforce this. So that being the case, I would think where practicable makes sense.
All right, cheers. Thanks for extemporaneously voicing your attorney opinion, which I know is not something lawyers like to do. What about others? Commissioner Messner.
The only thing that I wanted to there was a section in there, a reporting requirement as far as the drill rigs. I thought if, I would like to see a reporting requirement for both of these best efforts. And so I don't know if that language can just capture both of those things, but I think in the intent of trying to understand whether these best efforts COAs are actually successful or not, understanding the success of either of those would be great.
Mr. Chair, may I ask a clarifying question to Mr. Boudreau?
Yes.
Thank you so much. Mr. Boudreau, I believe to address Commissioner Messner's concern, your language that's already provided of operator will provide an update on the status of the operator's efforts to comply with this condition of approval reflects both the drilling operations as well as the permanent production facility. And if it's not in the right place, I guess I would say you could move that last sentence of number 1, just make it a number 3, and that encapsulates Commissioner Messner's concerns that we'll provide an update on both.
I agree with Ms. Jost. And another way to do it would just be to add the same sentence to the end of both COAs, but I think it's 6 of one, half a dozen of the other.
It doesn't matter to me. I was just making sure it was capturing both.
And Commissioner Messner, we understood it to be both. So thank you.
All right.
Would you like me to make an updated recommendation, Mr. Chair?
Please do.
So based on commission deliberations, I would recommend a motion to approve the application as applied for with the following 2 conditions of approval. 1, operator will employ best efforts to conduct drilling operations outside the May 1st through September 30th ozone non-attainment season and will utilize grid power where practicable for drilling operations if operations occur during the ozone non-attainment season. Operator will provide an update on the status of the operator's efforts to comply with this condition of approval. Number 2, the operator will make best efforts to electrify all permanent production equipment and the sites associated with the OGDP. Operator will provide an update on the status of the operator's efforts to comply with this condition of approval. And the commission directs ECMC staff to attach the supplemental practicability assessment submitted by the applicant on June 22nd, 2026 to the Form 2A.
So moved. Or actually, I think we had a motion from Commissioner Messner, so we may need to have him retract that motion, or he may already have. I'm losing track of time here.
I already rescinded it.
All right, so I would move that motion. Do we have a second?
Second.
Do we have further deliberation on the motion? Commissioner Messner.
I'd just take a quick second to highlight like the importance of the practicability assessments and the utilization of those in the director's recommendation with a full analysis and being able to have the and clarity around the timing of whether operators can submit the supplemental practicability assessments. You know, my understanding it was during the director's recommendation that no further after the director's recommendation that no further information can be provided, not after completion or I'm having a mental block, but I think the point is that completeness determination, that's what I was trying to say, because you are going to get more information after a completeness determination as the application evolves through technical review. And so the director's recommendation is the point. And whether that's clear or not, I don't know. I haven't looked at the guidance recently, but it makes sense to me that it would be the director's recommendation point that no further information could be provided before hearing. And so, but having that clear, whatever it needs to be clear, so that we're not having these, kind of challenges at hearing would be really helpful for me. Having more clarity in the director's recommendation around these practicability assessments and the analysis from staff would be helpful for me. So that we're not bumbling at hearing. And I think that would be my only ask, and I think this is a good example and lesson for like the need to make sure that, we kind of dot our I's, cross our T's, and button up whatever we need to button up associated with the practicability assessments. But appreciate the discussion here today. But I just wanted to make that comment.
Yeah, no, I appreciate that. And in my continued work with staff to process and prove how we work through OGDPs, I had a discussion yesterday around cumulative impacts and like where we need to go there and how much staff should be providing directional cumulative impacts or not. And that doesn't have to do with practicability assessment, but it kind of does. It's the same kind of thing. Is like how far do we ask staff to go? And so I directed staff to do an analysis of both cumulative impacts and practicability assessment and get back to the commission as a whole. And Ms. Joseph, we appreciate operators, lawyers thinking about that as well, so that we can have some consistent approach from the commission as a whole on both of those issues. So that's to be done. And I appreciate you bringing that up because I think it's an important point. And staff is going to continue to think about that and come back to us with some ideas around that. Other thoughts, deliberate thoughts on the motion that's on the table? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? All right, that motion carries. All right.
Thank you, everyone.
Thank you, Ms. Jost. So commissioners, we have one more OGDP before us, the Bison Operating LLC 251200264. I am not able to attend the rest of the meeting. And so I've got other ECMC business that's more pressing, which is weird, but true. So does anybody care to volunteer to chair the rest of the commission meeting? And then we're going to take a break and come back at like, I don't know, like 1:15 for that second OGDP. Commissioner Oath?
Oh, I'm happy to step in and guide us through the rest of the hearing, Mr. Chair.
Thank you very much. That might involve an executive session.
Yeah.
AAG Bedrow's got that set up. I thoroughly apologize to the listening community that I'm not able to attend. I promise you that the things I'll be doing are important to ECMC and transition with directors and interim directors. So with that, let's take a break until 1:15, and then at that point, Commissioner Oath will chair, and you guys can move forward. Thank you.
Okay, good afternoon. We are back. As was noted before the break, Chair Robbins had to attend to other commission business for the remainder of today. So we are continuing on with our agenda. Next up is docket number 251-200-264. This is Bison 4 Operating LLC's Black Tip 23 OGDP. And we will start with comments from Mr. Kavanaugh with Weld County.
Thank you, Commissioner Oath. Well, good afternoon, Commissioners. Thank you for the opportunity to speak for a few minutes regarding our process as it relates to Bison 4's oil and gas development plan. On September 10th, 2025, Weld County held a pre-application meeting for Black Tip 23 location before you today. Attendees included Bison staff, Weld County staff, ECMC. The 1041 WOGL application was received then on January 23rd, 2026. Weld County did not receive any public comments or applications for intervention on this location. The 1041 WOGL hearing for the Black Tip location was held on April 9th, 2026, and was approved by the hearing officer. Final order was recorded with the Weld County Clerk and Recorder and published in the Greeley Tribune, April 22nd, 2026, which creates a vested property right. 2A comments were submitted to the ECMC and were included in the Director's recommendation. Weld County agrees with the Director's recommendation and supports approval for this permit. And that's our comments for today.
Great, thank you. Any questions for Mr. Kavanaugh? Okay, seeing none, thank you. Appreciate
Thank you.
that. Next up, we'll move to a presentation from Bison 4 Operating. And then I think we will have a plan to go into executive session to receive information regarding trade secrets, privileged information, and other confidential commercial or financial data. Then we will come out of executive session and continue with commission questions and then deliberations. So with that, I see Ms. Gillen, and I thought I actually, oh, there, Ms. Vaselenki.
Thank you.
I thought I saw you before I switched to my other tab, and then when I came back, it got rearranged. So please continue.
Great. Thank you, Commissioner Oath. If we could have Zach Snyder appear on video. We just have 2 witnesses to swear in today.
So that's Ms. Gillen and Mr. Snyder, is that correct?
Correct.
Great. So I'll ask each of the witnesses to be visualized. When I call your name, please raise your hand, state your first and last name, and swear to tell the truth. Katie Gillen.
My name is Katie Gillen, and I swear to tell the truth.
Zach Snyder.
My name is Zach Snyder, and I swear to tell the truth.
Thank you.
Great. Well, we may share our PowerPoint, and then I'll get started.
Great. Thank you.
There we go. That looks good on my end. Well, good afternoon, Commissioners. My name is Kelsey Wazelinki with Jost Energy Law, and with Jamie Jost, we represent Bison 4 Operating LLC in the Black Tip 23 OGDP before you today in docket 2512-00264. We would like to thank Director Kavanaugh for his remarks today and Weld County for its support and participation in the WOGLA process, and also ECMC staff and the Director for their efforts on this OGDP. Next slide. The Black Tip 23 OGDP requests that the Commission establish an approximate 4,502.18 acre OGDP consisting of 1 new oil and gas location, developing 1 proposed drilling and spacing unit for the development of 16 total horizontal wells in the Niobrara, Fort Hays, Codell, and Carlisle formations. The proposed Black Tip 23 oil and gas location is shown on this map, which will develop 8 3-mile wells and 8 4-mile wells in an approximate 4,482.28 acre drilling and spacing unit proposed for the application lands. As stated by Director Kavanaugh, the proposed location is in Weld County, and the 1041 WOGLA permit was approved in April of 2026, creating a vested property right. The proposed location triggers 1 Rule 304(b)(2) ALA criteria, for being sited less than 1 mile from an RBU within a disproportionately impacted community. Notably, the location is sited outside of HPH, and there are no residences, schools, or high occupancy building units within 2,000 feet of the blacktip working pad surface, with the closest resident approximately 2,641 feet from the working pad surface. Bison conducted a detailed ALA and robust community outreach with nearby residents, which Bison will describe for you today. Regarding Rule 316C, in December of 2025, Bison submitted a practicability assessment with its Form 2A for 3 ESPs that apply between May 1st and September 30th in the ozone non-attainment area where practicable. Bison has determined that it is not practicable to use grid power for all permanent powered production equipment on site, that it is not practicable to power the drill rig engine with grid power, and that it is not practicable to not store produced water in permanent storage tanks on site. Again, Bison submitted a practicability assessment with the Form 2A in December of 2025 before any guidance was issued on practicability. Bison voluntarily supplemented the practicability assessment on June 30th of 2026 with supplemental information after reviewing the first draft of the ECMC's updated guidance document. I will note that the supplemental submittal supports Bison's original assessment on practicability and was submitted the same day that the director recommendation was issued by staff. Bison will review its practicability assessment in detail today and notes that the director's recommendation for approval of the OGDP noted no disagreement with Bison's conclusions on practicability. Bison has requested an executive session with the commission to discuss its conversations with the utility provider and certain confidential information. We are happy to enter into an executive session on these points where appropriate and likely after our presentation to you today. The director recommendation does contain one requested condition of approval, that the operator shall submit updated reference area photos taken during the peak growing season within 12 months of the Form 2A approval, and Bison agrees to this COA. And finally, Bison has complied with all notice requirements for the Blacktip 23 OGDP. No formal petitions were filed and no public comments were received on the Form 2A. I'll now turn it over to Katie Gillen to continue the presentation.
Thanks, Kelsey. Good afternoon, commissioners. It's a pleasure to be with you today, and thank you for your time and attention to hear our application. For the record, my name is Katie Gillen. I am the Vice President of Regulatory Affairs and EHS at Bison. I am here to provide you with an overview of the oil and gas development plan for the Blacktip 23 and to answer any questions you may have to the best of my ability. Also present with me today is Zach Snyder, landman at Bison. Next slide. This slide summarizes our permitting timeline. The 1041 WOGLA pre-application meeting for the location was held September 10th of 2025, which we will discuss in more detail on the next slide. ECMC, CDPHE, and BLM expressed no opposition to the proposed location. CPW was notified but did not participate as the location and access road are wholly outside of high priority habitat. The 1041 WOGLA for the location was approved on April 9th of 2025 at hearing. There was no public comment received. Bison received completeness determination for the OGDP on April 23rd of 2026. And the director's recommendation for approval on June 30th, 2026. CDPHE consultation pursuant to Rule 309F was required as the location is sited within a mapped DI community with RBUs within 1 mile. However, there are no homes within 2,000 feet of the location. CDPHE expressed no concerns and waived consultation. CPW consultation pursuant to Rule 309E was not required, and CPW did not request a consultation. There was no public comment received on the OGDP. Next slide. The pre-application meeting for the Blacktip 23 was hosted by Weld County on September 10th, 2025. The following Rule 301G 2B participants were invited: Bison 4 regulatory staff, representatives from CPW, Brandon Moret, and Lexi Hamos-Miller, representatives from ECMC, including Emily Waldron, Daniel Sharon, and Doug Andrews, all attended. BLM was invited but did not participate, as no federal minerals or lands were to be developed. Representatives from CDPHE, Tessa Sorensen, was invited and attended. Weld County staff all invited and attended. Also present was ECMC Community Liaison Jessica Chavez. Attendees engaged in a collaborative discussion that included all topics required under Rule 301 GAI through VIII, including the fact that the location was sited within a disproportionately impacted community. However, there were no RBUs, high occupancy building units, schools, childcare facilities within 2,000 feet of the location. Given there are homes within 4,000 feet of the location, a community outreach meeting would be required. Staff confirmed the area of evaluation would, the standard area of evaluation would apply. It was also confirmed that there was no reasonably foreseeable development identified within the area of evaluation. Several alternative locations were discussed, and Bison noted we had consolidated the original 2 proposed locations to develop the 2 DSUs into a single, centrally located location between the east and west units that allowed for significant reduction in overall surface impacts. This consolidation onto a single location to develop the same mineral lands was received favorably by all participants. Neither CPW nor CDPHE recommended any additional best management practices or enhanced systems and practices at the pre-application meeting. No one participating in the pre-application meeting identified anything that would prevent Bison from submitting the application for the proposed location, nor did they identify anything that would prohibit such development. A copy of the pre-application meeting notes were sent to all attendees and were attached to this application. Next slide. This slide identifies the mineral lands proposed for development within the Blacktip 23 drilling and spacing unit. The approximately 4,482 acre unit includes all of sections 1, 2, 11, 12, 13, 14, and 24 in Township 7 North, Range 63 West. Bison proposes up to 16 horizontal wells within the unit, 8 3-mile lateral wells, and 8 4-mile lateral wells. All wells will be drilled from south to north. The proposed wellbore locations will maintain subsurface setbacks of 300 feet along the east and west unit boundaries and 150 feet along the north and south boundaries. While the proposed Blacktip 23 surface location is sited within the mineral development area of the Wells Ranch Comprehensive Drilling Plan, which was approved by Order 1-241, permitted by Noble Energy, all minerals proposed to be developed by the Blacktip 23 are wholly outside of the CDP boundary. Bison has been in communication with Noble regarding the proposed development, and they have expressed no opposition to our application. As noted in the director recommendation, the best management practices proposed for the Blacktip 23 OGDP are as protective or more protective than the BMPs required for Noble's Wells Ranch CDP. Next slide. This slide identifies the proposed Blacktip 23 surface location in Section 23, Township 7 North, Range 63 West in Weld County. The nearest building unit and residential building unit are approximately 2,641 feet northeast of the proposed location. There are no high occupancy building units, schools, or child care centers within 1 mile of the location, and the surface location is outside of the floodplain. The proposed location is within a disproportionately impacted community, and residential building units are present within 1 mile. Accordingly, the alternative location criteria under Rule 304B2B apply and have been addressed through Bison's alternative location analysis. And I will just correct on this slide, neither the working pad surface or access road lie within CPW mapped high priority habitat. Next slide. An environmental justice report was generated and reviewed for the proposed Blacktip 23 location. The only individual DI criterion exceeded is the low income population criterion. The census block group is 42.69% low income, which is just 2.69 percentage points above the 40% threshold. All other demographic criteria are below their applicable thresholds. All CDPHE Reg 3 demographic triggers are below the DI thresholds. The location's overall environmental screen percentile score is 30.59, well below the applicable statewide threshold. Based on its review, CDPHE waived consultation for this location. However, Bison did not solely rely on that determination. We reviewed the report holistically, including the individual environmental health, demographic, and regional proximity indicators. Bison has incorporated siting, design, and operational best management practices to minimize potential impacts to the surrounding community, which have been included in this application. Next slide. This slide summarizes Bison's community outreach to for the Blacktip 23 project. For the pre-application meeting, Bison mailed bilingual invitation packets to all 15 nearby landowners within 4,000 feet of the proposed location. The packets included project information, maps, the anticipated development schedule, and instructions for participating in the OGDP review process. The pre-application open house was held on November 13th, 2025 at Briggsdale High School, a location selected in consultation with the ECMC Community Liaison, Jessica Chavez. 4 community members attended. To make the meeting accessible, Bison provided materials in English and Spanish and offered childcare, refreshments, and on-site Spanish translation. Questions focused primarily on haul routes, traffic, road maintenance, dust mitigation, operational timing, and mineral development sequence. Feedback was constructive, and mineral owners expressed interest in and support for the project moving forward. Bison subsequently held the required post-completeness community meeting on May 28th of 2026 at Briggsdale High School, and 2 community members attended. Their questions concerned haul routes, drilling direction, the number of wells, and pipeline takeaway. No significant current concerns were raised, and no comments required changes to the application. Overall, Bison provided a nearby, bilingual, and accessible outreach process that gave the community members meaningful opportunities to obtain information, speak directly with the project team and subject matter experts, and to provide input. Bison believes that our community outreach efforts comply with Rule 309C and the intent of the Statement of Basis and Purpose. Next slide. As required by Rule 304B2BX, Bison completed an alternative location analysis as the proposed working pad surface is within 1 mile of residential building units within a disproportionately impacted community. Again, there are no homes within 2,000 feet of the proposed location and no schools or high occupancy building units within 1 mile. Importantly, the entire drilling and spacing unit lies within the same DI community. Therefore, no technically feasible location would allow Bison to develop the DSU wholly outside of the DI community. So the alternative locations that were reviewed were also within the DI community. Bison evaluated the proposed location and the 3 alternatives shown here on the map which were also identified through the Weld County pre-application meeting process. The analysis considered proximity to receptors, wildlife, and high priority habitat, water and other sensitive resources, access, surface availability, and operational feasibility. The alternatives presented greater impacts or constraints. 2 are within mapped high priority habitat, while the 3rd would require longer drilling step outs, increasing operational risk, and potentially limiting full recovery of DSU minerals. Other constraints included proximity to aquatic resources, additional access disturbance, and absence of the surface use agreements. The proposed Blacktip 23 location was determined to be the preferred location because it allows the entire DSU to be developed from a single pad while maintaining more than 2,000 feet from nearby homes, avoid impacts to high priority habitat, and minimize impacts to public health, safety, welfare, wildlife, and water resources. ECMC, CDPHE, and Weld County identified no opposition and were in favor of the proposed siting. Next slide. The location is in a remote area zoned agricultural in unincorporated Weld County. The proposed location is within the boundaries, as previously discussed, of the Wells County CDP. However, all minerals are wholly outside. The proposed plan for the Blacktip 23 is to redisturb the existing location for a total disturbed area of 19.9 acres. Once interim reclaimed, the location will be 10.6 acres. The proposed access road will disturb just 0.1 acres and will be 82 feet long. Access will be off Weld County Road 71, and Bison has an executed surface use agreement. We are proposing to drill 16 total new horizontal wells. Gas pipeline takeaway will be installed at first production. Oil and produced water pipeline will be installed at first production, although Bison does plan to truck some portion of produced water peak volumes. Bison is planning for 4 produced water tanks. However, we will install no oil tanks. The produced water tanks will be equipped with tank vapor capture, which effectively makes their emissions zero while the VRUs are in operation. We are planning for gas-driven compression, which we will discuss more in our practicability assessment. Next slide. This slide reflects Bison's estimated operational timeline submitted at the time the application was submitted in December of 2025, which originally had operations commencing Q1 of 2028. At the time of application submission, Bison was running a single drill rig. Bison has since executed a second rig contract, and the Blacktip 23 will now be developed in Q2 of 2027 instead of Q1 of 2028. Therefore, our construction will begin April of 2027, drilling will occur May of 2027, completions August of 2027, and we anticipate first production December of 2027. Bison plans to develop the DSU in a single occupation. Next slide. This slide addresses the enhanced systems and practices, which I will now refer to as ESPs. The Blacktip 23 location is sited within the ozone non-attainment area. As such, Bison will comply with all Rule 316C3 year-round ESPs as shown on this slide. Next slide. During ozone season between May 1 and September 30th, Bison will comply with all applicable ESPs required per Rule 316C3B during ozone season. And to highlight a few, Bison will have committed gas pipeline takeaway and will shut in if gas pipeline is not available. For drilling operations that occur during ozone season, Bison will use Group 3 drilling fluid. Bison will, as practicable, implement the ozone mitigation measures on forecasted high ozone days, as noted in the rule. Next slide. Bison has evaluated each applicable rule under 316C4C enhanced systems and practices at the Blacktip 23 location under the required practicability criteria in Rule 316C4 D, I, AA through EE. For the limited ESPs Bison has found to not be practicable, the record demonstrates site-specific infrastructure and timing constraints, safety and reliability concerns, operational limitations, and alternative mitigation measures to avoid, minimize, and mitigate ozone season emissions. We will walk through Bison's practicability assessment for each of the 3 ESPs that will not be implemented at the Blacktip 23 location. This includes Rule 316C4CI, which addresses electrification of permanent production equipment, and Rule 316C4CII, which addresses all drill rig engines greater than 50 horsepower to be operated on grid power or non-fossil fuel generated power. And also Rule 316C4C III, which requires that the operator not store produced water on site, except for normally empty maintenance tanks and tanks used for produced water recycling. Bison provided a practicability assessment at the time the application was filed and provided a supplemental practicability assessment to address electrification. that was incorporated into the director's recommendation. Next slide. With respect to Rule 316C4CI, electrification of permanent production equipment, Bison's Form 2A response is no. The ESP applies but is not practicable. Bison submitted a service request to Poudre Valley Rural Electric Association, the utility power provider in the area, on April 10th of 2026. Bison requested service for approximately 3 megawatts for temporary drilling, with a requested connection date of May 1st, 2027, and approximately 3 megawatts for permanent production loads. 3 to 3.5 megawatts for drilling. On April 13th, 2026, Poudre Valley advised that given the location and requested need by date, serving the load appeared to be extremely challenging. But Poudre Valley was willing to run the request through its study process. To facilitate a complete record for this hearing, Bison requested that Poudre Valley provide preliminary findings in advance of its final analysis. Poudre Valley provided those preliminary findings to Bison on June 25th, 2026. They continue to conduct their technical engineering study, which has not been finalized at this time. Based on Poudre Valley's preliminary findings, full grid electrification of the permanent production facility is not currently available within a committed or confirmed schedule that would support the proposed development timeline. Consequently, the required electrical infrastructure cannot be relied upon for project implementation at this time. Based on Poudre Valley's current preliminary assessment, permanent facility power would require significant upgrades and approximately 9.2 miles of line rebuild and approximately 0.5 miles of line extension to the site. In all, approximately 9.7 miles of total line work. Poudre has stated that these upgrades would come at a significant cost and would potentially delay the project by several years. Given this is business confidential information, we have requested an executive session to share this information with commissioners at the end of our presentation in more detail. Poudre Valley continues to complete their technical engineering review and have advised that existing infrastructure with 0.5 miles of new line construction may be able to support partial electrification of some permanent production equipment, but have not provided any commitment of service or any portion of the project at this time. Bison also evaluated on-site solar as the power source. The solar power system cannot reliably support continuous production and safety critical equipment during nighttime hours, winter conditions, prolonged cloud cover, and peak operating loads. It would require extensive battery storage, not readily available, backup generation, and a substantially larger surface footprint, nearly twice what we anticipate for the production facility. Those additions would increase land disturbance, requiring an estimated 20 acres, and wildlife impacts while eliminating the need, eliminating the need for reliable backup power source. We acknowledge the benefits of connecting to utility line power and associated emissions reductions and continue those efforts rigorously under our greenhouse gas intensity programs. Full electrification of the production facility could reduce NOx emissions However, the local utility is currently unable to commit to providing the electrical infrastructure and service needed to support the loads required. Based on Poudre Valley's preliminary assessment, electrification would require substantial utility upgrades, including construction or rebuild of the line discussed before, additional extension to the site, and utility-led engineering and design, and right-of-way acquisition and construction. Poudre Valley has also indicated that the work could delay the project for several years and that it cannot commit to a service schedule compatible with Bison's development timeline. With respect to rule section DD on non-applicability, this ESP does apply but is not practicable. With respect to double E, alternative methods that Bison will employ, we will use low emission engines that comply with applicable Colorado air quality requirements, and we are committed to designing the facility to allow conversion to full utility or to utility electrification when adequate service is available. Should partial utility power become available by Poudre Valley, we would be able to electrify some portion of the production equipment. Poudre Valley is studying a partial load option utilizing existing infrastructure that would require just the 0.5 miles of line extension, and we will continue to work with them on that. While the facility will be designed to operate on electrical power and allow for conversion to grid power once it becomes available, reliance on the electrical grid is dependent on significant utility upgrades and operational approvals that are outside of Bison's control, and as it currently stands, is not practicable. While we recognize that enhanced systems and practices are evaluated independently from the NOx intensity and greenhouse gas intensity targets, Bison's performance under those programs remains relevant evidence of a broader commitment to emission reductions. Bison is meaningfully outperforming its applicable NOx intensity target and remains below its greenhouse gas intensity target through asset-wide electrification strategy, operational planning, and other emissions reduction measures implemented beyond the scope of this commission's project-specific review. We are not offering that performance as a substitute for the required practicability analysis. We do, however, ask that the record reflect that Bison's overcompliance demonstrates its continued use of alternative methods to reduce emissions from development where those measures are safe and practicable. Next slide. With respect to Rule 316C4, CII, all drill rig engines must be powered, greater than 50 horsepower must be powered on grid power or non-fossil fuel generated power. Bison's Form 2A response was no. The ESP applies, but is not practicable. With respect to availability, our testimony regarding the timeline of engagement with Poudre Valley is the same as previously stated. For the drill rig load, we had requested 3 to 3.5 megawatts, and Poudre Valley has not committed to service, design, cost, or schedule, and indicated it would likely take several years and has not provided any date more certain. There are two options from their preliminary assessment that were provided, neither of which meet the development schedule, offered greater availability, or improved operational difficulty. Nonetheless, Poudre Valley has two options available. Option one, reconstruct 17 miles of line, and then add an additional 0.5 miles of new line extension. The second option would be to build a new substation and also construct about 9.3 miles of line. This would also require that Tri-State complete a transmission study, which they indicated they have no control over that timing. Hooter Valley has stated that these upgrades would come at a significant cost and would potentially delay the project by several years. Given cost information is business confidential, we have requested an executive session to share this information with commissioners at the end of our presentation. With respect to adverse impacts, electrification of the drilling rig would require construction of a new substation plus 9.7 miles of line upgrades or approximately 17 miles of electrical line rebuild. That infrastructure would likely create substantial land use impacts that may be well beyond the impacts associated with the drilling emissions of the proposed Black Tip 23 wells. Construction would require development of a new utility corridor across multiple properties and existing land uses, resulting in surface disturbance, construction traffic, vegetation clearing, and ongoing maintenance requirements. These impacts would affect a significantly larger group of landowners and stakeholders than those potentially associated with the Black Tip 23 project. Given that the drilling load is temporary, the long-term land use changes and construction-related disruptions associated with building permanent utility infrastructure are disproportionate to the short-term benefit of electrifying the drilling phase. With respect to CC, emissions reductions versus operational difficulty, Bison evaluated the potential emissions reductions associated with electric drilling and estimates that NOx emissions could be reduced by approximately 17 tons and VOCs by approximately 11 tons during the drilling phase. While those reductions are meaningful, electrification is not currently practicable because the electrical service necessary for drilling is not available. Therefore, as a result, the infrastructure could not be constructed within the time frame compatible with the project. Therefore, although Bison recognizes the environmental benefit of electrification through drilling, although Bison recognizes the environmental benefits of electrification, drilling is temporary in nature. Those benefits do not overcome the current utility constraints, extended infrastructure lead times, and schedule incompatibility with the project. With respect to EE, alternative methods, the project will utilize modern natural gas-fired spark ignition drilling engines, a cleaner burning technology that substantially reduces NOx, particulate matter, and greenhouse gas emissions compared to traditional diesel-powered rigs. In addition, drilling activities will be sequenced to minimize idle time and unnecessary engine operation, further reducing fuel consumption and associated emissions. While we recognize that enhanced systems and practices are evaluated independently from compliance with NOx and greenhouse gas intensity, Bison's performance under those programs remains relevant of its broader commitment. Bison is meaningfully outperforming its applicable NOx intensity target and remains well below our greenhouse gas intensity target through asset-wide electrification planning, the use of electric drilling where feasible, and other emission reduction measures implemented beyond the scope of the Commission's project-specific review. Next slide. This slide addresses the practicability of eliminating produced water tanks from the facility. Bison intends to maximize produced water takeaway through our produced water pipeline system. However, the available capacity of that system during peak periods of peak production and early flowback may exceed that of pipeline capacity. In addition, produced liquids may require additional residence time, settling, or treatment before they can consistently meet pipeline specifications. As a result, 4 produced water tanks are necessary to provide operational buffering capacity and treatment flexibility. The estimated emissions associated with these tanks are extremely low, estimated at just 0.11 tons per year of VOCs. That is less than 1 ton. And 0.46 tons per year, 0.02 tons per year of NOx, both less than 1 ton. Additionally, the produced water tanks allow for trucking for short-term peak volumes in excess of pipeline capacity. The associated produced water hauling truck trip emissions are estimated at just 0.029 tons per year VOCs and NOx at 0.46 tons per year. While eliminating the tanks could result in additional emission reductions, doing so would create significant operational challenges. This approach would increase system complexity, expand the facility footprint, create additional equipment components and connections, and increase potential leak points. It could also increase the likelihood of production shut-ins, operational upsets, intermittent venting events, and unplanned trucking if pipeline capacity becomes constrained. Bison believes that the vapor-controlled storage tanks equipped with vapor recovery units, which again capture and control emissions up to 100%, are a more reliable and predictable method of emissions control than a tankless configuration operating under variable field conditions. We included these produced water tanks to primarily address peak flow rates. Bison is willing to commit to remove these tanks after peak flow rates, which we anticipate will be roughly 4 months after the first date of first production. Next slide. The Blacktip 23 location is sited within a disproportionately impacted community, and Bison recognizes the importance of developing this project in a manner that minimizes impacts to nearby residents and sensitive receptors. Consistent with commission requirements, Bison will implement all enhanced systems and practices applicable for facilities located within a DI community. Next slide. In culmination, the director's recommendation with respect to cumulative impacts, staff are not seeking any additional COAs related to Bison's NOx and greenhouse gas intensity. Based on Bison's NOx intensity status, staff does not anticipate the approval of this OGDP's operations to adversely affect Bison's ability to maintain current NOx intensity status. We are beating our target by 32%. Staff also confirmed that the appropriate area of evaluation was used in the cumulative impacts review. Bison believes this is an excellent location, meets the requirements of the new cumulative impacts rules, and has a robust director's recommendation. Next slide. In conclusion, staff has recommended the following COA: that we shall submit updated reference area photos taken during the peak growing season within 12 months of the Form 2A approval, and we agree to be bound by this. With respect to public health, safety, and welfare considerations, the proposed location working pad surface is greater than 2,000 feet from any RBU, HOB, high occupancy building unit, school or childcare facility. Therefore, Rule 604B siting requirements do not apply to the proposed location. Bison completed an ALA and submitted various BMPs to address impacts from noise, dust, light, and odor nuisances. CDPHE expressed no concerns with the location and has waived consultation. With respect to community outreach, Bison's efforts regarding community engagement were deemed compliant, and staff noted we met the intent of Rule 309C and the Statement of Basis and Purpose. On the issue of wildlife, the proposed location and access road are wholly outside of high priority habitat, but Bison has agreed to BMPs to minimize impacts on wildlife. CPW expressed no concerns with the location and consultation was waived. The director has obtained a full review, including all supplemental information, and has deemed this application approvable. Now I will turn it over to Kelsey to conclude our presentation.
Thank you, Katie. So to summarize the Blacktip 23 OGDP and request for approval, I'll note again that the 1041 WOGLA permit has been approved by Weld County, creating a vested property right. No comments were submitted on the 2A and no formal petitions were filed. Bison engaged in robust consultation with nearby residents throughout the OGDP planning process and commits to various BMPs to address impacts from noise, dust, light, and odor. In addition, Bison will develop the 16 wells in one occupation and commits to 3-phase pipeline takeaway with a limited number of produced water tanks on site temporarily equipped with tank vapor capture. Bison will construct the facility so that it can be connected to line power should line power become available and practicable in the future. And based on the record before you, the OGDP complies with the Commission's rules. And for these reasons, we respectfully request approval of the OGDP, the Form 2A, and the spacing application. So this does conclude our presentation. We can take the PowerPoint down and we are open for any questions.
Thanks for your presentation. I think what was contemplated was that we would go into executive session at this time to take additional confidential information and address questions on that information, and then come back out and address questions on the non-confidential information. Commissioners, are you comfortable with that approach, or does anyone want to cover questions first? Okay, I saw a couple heads nod. Okay, AAG Boudreau, please step in here for executive session assistance.
Thank you, Chair. Oath. Pursuant to open meetings law, the Commission is entitled to enter into executive session at this regular meeting to receive confidential commercial data pursuant to Colorado Revised Statutes 2472, 204, 3A4, as authorized by Colorado Revised Statutes 246, 402, 3A3. Specifically, the Commission will receive confidential commercial information regarding the Bison 4 Blacktip 23 OGDP, ECMC docket number 251-200-264. Chair Oath, you can entertain a motion to enter executive session for the matters and purposes I just described.
I will actually just go ahead and make that motion.
Second.
Any discussion on the motion? All of those in favor?
Aye.
Signify by saying aye. Aye. Any opposed? Okay, motion carries 4-0. We will adjourn to executive session. I believe the link has been shared with all the necessary folks. Okay, thanks, Ms. Wazelinski, for the head nod there. So we will adjourn from the public session, enter executive session. For those who will be waiting, we will return as quickly as we can. So just hang on here. Thanks so much. Okay, we have returned from executive session. AAG Boudreau.
Thank you, Chair Oath. The Commission is returning from executive session. During executive session, the Commission received confidential commercial data pursuant to Colorado Revised Statutes 2472, 204, 3A4, as authorized by Colorado Revised Statutes 246, 402, 3A3. Specifically, the Commission received confidential commercial information regarding the Bison 4 Blacktip 23 OGDP, That's ECMC docket number 251-200-264. No deliberations were held, no votes were taken, and no decisions were made. Chair Oath, you can entertain a motion to exit executive session.
I will move to exit executive session. All those in favor? Aye. Any opposed? Motion carries 4-0. Okay, we are out of executive session and can entertain questions from commissioners on all of the non-privileged information that has been presented. Commissioner Messner.
Thank you, Madam Chair. Ms. Gillum, a couple questions. In your presentation, regarding ESPs that you are committing to, and I missed what page it was, and so I apologize on the presentation. But it was regarding the lacked commitments. It talks about a second occupation there. And so I'm trying to understand, because you indicated that you're doing this in one occupation, but I believe the slide said you would commit to it on your second occupation. And so I'm just trying to clarify.
Yeah, apologies. I would need to go back and find what slide, but that's not correct. We intend to develop in a single occupation.
And so the commitment to lacked would be
First occupation.
Immediate.
Correct.
Yeah. Okay, just a clarification there. So talk to me a little more about the kind of surge trucking associated with produced water. What's the capacity of the line, and what are we talking about from a truck trip standpoint? In the surge capacity, how many years are we talking about surge capacity? Is it more trucking, the majority trucking, or the minority trucking, or what are we looking at here?
Yeah, so we anticipate peak production happening within 4 months, and that's an estimate. But certainly not talking about years here, we're talking about months. So we anticipate truck trips to be, and just let me pull these notes up. So give me 1 second.
Sure.
So during that time, we anticipate around 60 truck trips per day for water hauling over that period of 4 months. So we would only be, I need to confirm that is correct with my team. Do you mind if you give me a second to confirm my truck trips are accurate? I know that our pipeline capacity, we would only truck above the pipeline capacity. Sorry, just give me 1 second.
And Katie, if you need to come back to this question, we could maybe pin this and come back with your number and keep going on any other questions.
Yeah, that would be helpful, since I don't want to give the wrong information and I'm just scrambling to find those numbers right off the tip of my fingers. But I do have our numbers that are associated with the emissions of our truck trips, which was provided in advance of this hearing. I just need to find the basis of the truck trips that are associated with that. So the VOC emissions that we would anticipate would again be 0.02 tons, and the NOx emissions would be 0.46 tons, and that's for the truck trips that would be associated with just this short period of peak production hauling. And then for the tank emissions, we're looking at both less than a ton of VOCs and less than a ton of NOx. And that's because one, there are not typically a lot of emissions associated with the produced water, but most importantly, we are equipping those tanks with a tank vapor capture, which controls emissions by 100%. So the emissions associated with our request really are very minimal, both on the truck trip side and the emissions associated with the tank.
Yeah, thanks for that. I caught that in your presentation, and so I appreciate the information on the emissions. I was just looking at kind of overall truck trips and, whether we're talking about the timing of it. And so the 4 months, if it's accurate, makes sense to me. I do think there's still emissions associated with vapor recovery units because you are taking that into a flare that has some emissions associated with it, right?
No, that gas is captured and sold.
Okay, so
So
it's a
yeah, then
it's a
the
full
gas
capture, so
is,
it's not routed to the high efficiency flare.
that's correct. Yeah, those emissions are captured, recovered, and sold.
Okay, thanks. That's helpful. So, when we're talking about the ESP associated with drill rigs, I understand your arguments associated with the practicability of being able to access grid power in order to run those drill rigs. Kind of the bigger picture is understanding the need to actually drill inside of the ozone non-attainment season rather than outside the non-attainment season where that ESP then wouldn't even apply. And so maybe talk a little bit about what the need is in order to be able to drill inside of the non-attainment season versus outside of the non-attainment season, which is kind of the first piece of the mitigation hierarchy, which is avoid.
Yeah, just want to make sure I'm off mute. One of the biggest reasons is we are currently running 2 rigs. Many of our development timing is contingent on having permits approved, so that we can have a complete development schedule. And like I said before, because we are running 2 rigs, I will work with the team to determine whether or not it is possible to drill the Blacktip 23 outside of ozone season. The one difficulty that I face is it is 16 wells. It's a large number of wells, and it's 8 4-mile laterals and 8 3-mile laterals. And so it's not a short duration of drilling. And so it makes it very difficult for me to schedule the full development of drilling outside of ozone season. But we will make best efforts to get to drill outside of ozone season. It's just a large number of wells and a lot of drilling.
Okay. With the production facility itself, and so a statement then a question. So I think one of the statements that was made both in the director's recommendation, and I think you've reiterated it here in your presentation, is that that this proposal is as protective or more protective than other operations inside of the comprehensive drilling plan or the CDP. The one OGDP that's been approved inside of the CDP has committed to electrified production equipment. And so actually that statement is inaccurate, that this, if as proposed, would be potentially less protective because it doesn't have electrified production equipment associated with it. the question I have is what with the existing grid power that's available in proximity without upgrading that, what production equipment can be run?
I think we're still very much learning that. We're still waiting on a response from Poudre Valley to make that determination. But as I testified earlier, we are constructing the facility so that it could be converted to partial power when that becomes available. I just don't have information from the utility provider at this time to know exactly what that will be. And
Okay.
I
Do
also
you know what the capacity is right now? Because I think you're indicating somewhere between 2 to 2.5 megawatts needs for the whole production facility. What is it sized at now?
I think we don't know. We know it's less than 3. We know it's less than 3 megawatts at this point. I think right now the things that they are studying is the reliability to be able to provide some of that power.
Okay.
And I just wanted to add with respect to the comment on, if I may, the Wells Ranch CDP, that was provided by staff, and that was staff's comment based on their review of the Wells Ranch CDP and our application.
Correct. I saw it in the director's recommendation. You just reiterated it in your presentation.
Yeah.
Okay, I think that's the questions that I have. If you do get more specifics on any of the like truck trips, that's I don't need it immediately, but maybe at the end of questions, if that comes up, then that'd be great.
Okay. What we'll do is maybe go through the rest of the questions, Ms. Gillen, and then if there's any other things we need to add to that list, then we can take a break for you to track that down and come back. How's that sound?
That would be most helpful. Thank you.
Great. Okay. Commissioner Cross.
Thank you, Madam Chair. A couple quick questions. I know there was some discussion that you had in your testimony about the potential substation being built. Do you know if part of that analysis is that they've had, if they would have use for that substation beyond your development? Is this planned for other things being built in the area for them, or would this kind of be something that they'd be doing for Bison for this operation?
I think given they haven't indicated any other development that would make this project more feasible, my assumption would be that no, they don't have any other planned development. I believe they would have indicated that in their preliminary assessment to us, and given us some more indication of hope.
Okay. And I want to follow a little bit on what Commissioner Messner asked about as well with respect to the water takeaway. In your presentation, you talked about it being, I think you used the words unclear if there would be capacity to take water away. What is unclear? Do you have an idea of, is it a matter of you don't know how much produced water you're going to have? You don't know the capacity of the pipeline? I'm just hoping for a little more information on that.
Trying to review my testimony, I don't believe I intended to testify that we didn't understand our pipeline capacity. We will have pipeline capacity connected to the facility We will deliver the vast majority of water through that produced water pipeline system. And we do anticipate, because this is such a large facility, 16 wells, 4,400 acres approximately of development, that we do anticipate exceeding our pipeline capacity here, and we'll need to do some temporary trucking. Is that help? Does that answer your question?
It was just a little as you go into it and kind of the idea that you do plan to have produced water takeaway, but you're pretty sure the 4 tanks is enough? If it's found to be too much, are you going to take tanks away? Has any analysis been done on that?
Yeah, the 4 tanks were designed based on the anticipated peak flow rates above our pipeline capacity. So yes, that was the designed intent.
And is there an intent to remove those produced water tanks once you're past that peak production point?
Yes.
I don't want to dwell into it too much. I'm also interested to hear a little bit more about the drilling with the second rig. I wasn't sure if it was because you talked about moving timelines up, but as you move the timelines up, it kind of went right into the middle of the ozone season with the timelines on that second rig. And so as you provided some answers to Commissioner Messner there about wanting to look at if it could be done outside the ozone season, is that something that has not occurred yet?
In other words, have we not evaluated whether or not we were able to do that?
Correct.
The biggest challenge is a large portion of our operations to the north is all within high priority habitat. And so between the 2 rigs, we are trying to accommodate a schedule that allows us to meet those high priority habitat STIPs. And so, yes, we have provided the best possible schedule to date that we believe addresses all of our obligations under our OGDPs. So yes, I think that work has been done.
So this is sort of a balancing act between already permitted OGDPs that are scheduled around timing steps and consultations with CPW and trying to fit this in now more so than, oh, we now have a second rig. We've scheduled it now and we're looking to see if it can be changed.
That is correct.
Okay. Okay. Those are my questions for now.
Commissioner Ackerman.
Thank you. And it looks like we're all copying off of each other's notes here. Mine are the same. I just wanted to make sure that I reiterate that I also had the same questions, and I would like clarification, and for the future, upfront clarification. If we're going to, truck a portion of the water of the actual analysis that's been done, then that at least helps us understand what those averages might look like, what the number of truck trips might be. These are questions that we've asked pretty repeatedly. Any analysis and averages that are provided beforehand would really help us determine the impacts of these kinds of proposals in advance instead of on the fly. And so any more information you can provide on that, I certainly am interested. And I appreciate the clarification on being able to modify the drill rig schedule and modify outside of ozone season. I guess the problem with doing this on the fly is that my question to you would be, what are the chances? How have you gone through the evaluation to see, based on today's discussion, how far outside of ozone season, or at least towards one end of ozone season, could you make it? Or is this your final answer? Is that's proposed right now? It's really hard for me to to determine that at this point. Does that question make sense, Ms. Gillen?
I think, we're open to continuing best efforts to evaluate our schedule. I think we've brought a really thoughtful, well-planned schedule before you today that has evaluated our entire development and our obligations to comply with high priority habitat STIPs. But,
Thanks. I understand your argument that you've already made. I'm just wondering if this is your final answer or if there's room for modification still. It's hard for me to ascertain that.
Well, perhaps, Ms. Gillian, if you want to take that under advisement to consider as we take a break and respond after you've had a chance to look at some additional analysis that has been requested, as well as some thinking on the question on the drilling schedule.
Thanks, Chair. Oh, I'm sorry. Go ahead.
I was going to reiterate the extra time here for Bison to come back with a thorough answer to your question, Commissioner Ackerman. I think we understand where you're coming from. Just a little bit of time would be helpful.
Sure. Thank you. Of course. And I do have another question, but I noted Commissioner Messner's hand up that might be related.
Well, as you're thinking about it, I wanted to add on one question there too. So I want to confirm that you're using 2 drilling rigs on operations in high priority habitat, or whether you have 1 drill rig operating in high priority habitat, and this is a second drill rig that is dedicated to this proposed project.
I'm not sure I fully understand the question. Each drill rig has some locations that are within high priority habitat. We don't have a rig exclusively, dedicated to non-high priority habitat. But maybe I misunderstood your question.
Yeah, and maybe I misunderstood. I think what I thought I heard you say is that you have been running 1 drill rig and you were able to acquire a second drill rig, which led me to believe that this new drill rig was going to be this may be the first project that this new drill rig may be operating in. And there was just the 1 drill rig that is currently operating. And maybe I'm misunderstanding, but.
Thanks for that clarification. So we have contracted that rig. It will begin drilling or by the end of the month, early next, and will then begin a continuous program. So no, the black tip will not be the first pad contracted for that rig.
Yeah, that's helpful. Sorry, Commissioner Ackerman, I thought it was relevant to what you were asking, but it's not. So.
Absolutely no sorry at all. I mean, those are the kinds of nuances that I hope to understand in kind of evaluating the constraints. So thank you. One of the things when I look at practicability assessments that I often see, including this one, is a statement that we've talked to a provider and there's no way they can do it in time. And I do recognize, and I don't say flippantly, let's talk about timelines, but because I do recognize the complexity of the timelines and all of the moving parts that you're dealing with, but this is becoming certainly a recurring issue. And one of the things that I noted in the documentation is that, you based a lot of your arguments on saying that, the PVEA, they can maybe look at it, but they're way down the road to get anywhere with it. But I do see that your application was first submitted on the 31st of December of last year. And the initial steps, as far as I can tell from the documentation with the provider, happened on April 10th. And so I don't know if I'm missing something there. Was there significant outreach to the provider prior to the first May 10th date or April 10th date that I see there? And what was the to the extent that you can share, were there discussions prior to that?
Yeah, I can share. So this is a unique pad where it is right on the territory border between Excel and Poudre Valley. So there were some preliminary conversations with Excel and Poudre trying to sort out who would ultimately be the power provider for this area. Bison worked extensively with these two providers to try and get an answer. And so that was part of the preliminary conversation, is who ultimately would provide power to this pad.
Oh, Commissioner Ackerman, you got muted.
Thank you. And so when you're talking about extensive communication with these entities, you're talking that predated your application, or I'm just kind of looking for a timeline of communication here.
I don't have that record handy, whether it predated our application. Typically, we have an understanding of who the power providers are in the area. We try to learn as early as possible the capacity that is available. Before we can submit a service request, we have to, put together an application, have an executed SUA, have a good load estimate of what would be required, and then, we submit our service request. So on our part, it does require many things be finalized before we can even submit that service request.
Sure. Yeah, thank you. I understand that. I'm not sure that you have to have all those things in place before preliminary communications begin and understanding the lay of the land, but I get where you're coming from there. So I'll move on from this point, but it's certainly something that I noted in the application, and something that's difficult for me is the argument of, well, we can't do it in time, but we haven't had those discussions until after we submitted our application. That's a little hard for me to say that it's meeting best efforts, but I'll move past that point and to my last question, and this is just kind of a follow-up on the produced water discussion. And you're asking for 4 tanks there, signifying a pretty substantial amount of stored water on site for short periods of time. It's a 2-part question. Did you have data that you based the number of tanks on there that were needed for a certain period of time? And is there an intent to remove tanks afterwards, or just leave them on site?
Yeah, so we've previously testified to this. So we will remove the produced water tanks from the location after peak volumes. And we are able to send 100% of the produced water down the pipeline. So I have previously testified to that fact and just confirming it. And then, yes, we did use forecasted volumes for the design of how many tanks would be required for the facility for the 16 wells. And again, we are committing to removing all 4 tanks after what we anticipate will be peak volumes achieved in just 4 months' time.
And thanks for reiterating that for me. I must have missed it in your testimony as I was taking notes, but I appreciate that. I think that's all I have for now, Madam Chair.
Great, thanks. Any additional questions before we take some time to give the operator some time? Ms. Wazelinski, 10 minutes, 15 minutes?
Let's do 15. And just for a little bit of clarity, I understand there's an outstanding request for truck traffic numbers associated with the produced water tanks, and also a request for maybe more specifics around timing of drilling operations. Are these the 2 outstanding items?
That's what I have also. Anything else, commissioners, that you would like in follow-up? Commissioner Ackerman?
Thanks. I mean, if possible, it would help me if you could substantiate some earlier communication with the potential providers as well. Thanks.
Yeah, timing of when communications began with the utility providers. Okay. All right, 15, so what is that? 12 after? All right, we'll see you at 3:12. Okay, we are returning here from a break. Ms. Wesselinki and Ms. Gillen, hopefully you've had some time to look into the questions and would like to hear from you.
Okay.
Gillen?
Yep. So we did get clarification on truck trips. Apologize for not having those in hand at the time, but to clarify, in month 1, we do anticipate around 60 truck trips per day. And then by month 2, that will essentially drop in half to around 29 truck trips per day. And then it very rapidly declines after month 2. And we anticipate being 100% on pipeline within an estimated 4 months' time. At which point, as I've testified before, we will remove all 4 tanks from the facility. Any other questions on that? Otherwise, I am prepared to answer some of the other questions on the other issues.
Not seeing any takers on follow-ups on truck traffic, so I think we can continue.
Okay. And then with respect to our first engagement with Excel, we started these conversations with Excel for providing power in this area back in very early 2024. In about February of 2024, Excel denied service for this area, at which point we began looking at other options with Cooter Valley. And if there's nothing further there, I'm ready to address our drilling schedule and our commitment for continuing to work with the utility provider on partial electrification connection, but I'll just stop there.
Yeah, looking to see any follow-up questions on timing of communications and substantiation of communications. Okay. Go ahead, Ms. Gillen.
Great. And then as the former operator just previously agreed to this COA regarding drilling, we're also willing to agree to this. And I'll just read for the record this COA. So Bison is willing to commit to the operator will employ best efforts to conduct drilling operations outside the May 1 through September 30 ozone non-attainment season, and will utilize grid power where practicable for drilling operations if operations occur during the ozone non-attainment season. And then secondly, with respect to production electrification, you're willing to agree to this COA. Operator will provide an update on the status of the operator's efforts to comply with this condition of approval. And 2, best efforts will be made to electrify all permanent production equipment and the sites associated with this OGDP. Operator will provide an update on the status of the operator's efforts to comply with this condition of approval.
Anything further, Ms. Gillen?
I have nothing further.
Okay, Commissioner Ackerman.
Thank you. I think I understood that. Just one point of clarification on that last point. I I heard a commitment. I was clear on the commitment on the outside of ozone non-attainment season. I wasn't clear on the commitment on electrification of permanent facilities. I heard a commitment to provide an update on the status, but is there also a commitment to put forth best efforts to actually electrify the production equipment?
Yes, there is.
Thanks for the clarification.
And I guess I want to follow up on the idea of a COA of best efforts around drilling outside of the ozone season. The schedule proposed here is different than what was contemplated in the previous OGDP, in that you're proposing to begin in April, and as you testified, Ms. Gillen, it's a large number of wells, and so will take an extensive amount of time. And so I guess, could you speak more to what those best efforts look like for you? Is it an effort to and likelihood of being able to obtain a drilling rig earlier, enough time to avoid, or to begin later? If you could elaborate, please.
And Commissioner, maybe perhaps Ms. Gillen, before you answer that, I just want to maybe put a little finer point on the best effort standard here. I think the commitment is obviously for Bison to use those best efforts, and we did have a discussion in the prior hearing of the legal standards around that standard, to have drilling be outside the ozone season. I think factors that go into that analysis are length of drilling operations, availability of drilling rig, timing of permit approval. There's multiple things that would go into that analysis, which if for some reason Bison were unable to comply partially or fully, that's the purpose of the written report to the commission. And so I think at this point, I think it's hard to say exactly what that best effort standard looks like, because the time hasn't come for that standard to really come before you in terms of any type of written report. So I just wanted to maybe put that thought out. And Ms. Gillen, if you have any further thoughts on timing of drilling operations, certainly go ahead.
I think that's right, Kelsey. We believe we've put forth a very thoughtful schedule here. I know I have testified to the fact that there are 16 wells. We have other projects pending permit approval, to Kelsey's point. I think that is why we are committing to this best effort, is so that we can continue to evaluate this process. But right now, I believe I have brought forth the best schedule that has considered those things now. And Bison is committing to, maintain and continue that best effort, as really critical new information becomes available that would allow us to modify our schedule.
Yes, Commissioner Ackerman.
Thanks. I don't mean to interrupt your train of thought there, Madam Chair, but
Not at all.
I understand the reiteration that you like the schedule that you brought forward, so I'm not sure there's a need to reiterate that. But I do think that in the end, what I'm looking at here is it's difficult to say that from the perspective of our regulations and putting forth best efforts to avoid ozone non-attainment season, yet failing to consider modifying the start date that clearly takes you into ozone season rather than avoids it, differentiates this significantly from the previous application that we've heard that you've equated it to. And I don't feel like I've had that question answered, other than my assumption is that the intent is to go forward with the schedule as planned, yet continue to evaluate maybe whether you can change it. Is that what I'm hearing you say?
Yeah, I think there are, things that are essential for development, like midstream takeaway, so that we can comply with our, pipeline COAs. And so, an example of maybe potentially being able to move a schedule is maybe we can get pipeline takeaway to a facility earlier. That's why I think we have standards like this best effort to continue to evaluate, other development essential critical path items.
If I may, Commissioner Ackerman, I think when we talk about schedule and when schedules are presented at an OGDP hearing, they're truly based on estimates. I think, Bison's certainly not committing to the schedule they presented. And in fact, based on discussions and this best effort standard, that schedule would need to move. If best efforts are to be made to keep drilling outside of ozone season. So, I want to make sure we're consistent in our message here is that the schedule presented was an estimate, but this commitment sort of goes over and above the estimated schedule to use best efforts to keep drilling outside of the ozone season.
Thank you for that clarification.
Okay, any additional questions? Okay, thanks, Ms. Gillen and Ms. Wozzelinski. We will turn to deliberations. Commissioner Cross.
Thank you, Madam Chair. I'll just provide some initial thoughts. I think overall, I do think that the COAs proposed provide a little more comfort. That said, I think especially as it comes to the drilling timeline, I do see this as materially different than what we saw in the previous application. In the previous application, no, we are planning to drill outside the ozone season. Our concern is if something runs long beforehand, or if we run into problems in drilling and we start to run into the beginning of ozone season. That's a lot easier to digest when you're looking at taking the best efforts as compared to, well, our proposed schedule is to do it right in the middle. And so right now we're more in admittedly it's estimates, but now we're more of in a situation of now we're being told that they're going to make best estimates to keep it out of ozone season, but we don't really know when that might be. We're kind of looking at things from a different starting point. So I do have some concerns with that. Again, I think that the COAs make me more comfortable with it, but I'm not 100% sure I'm sold on it. One thing that came to mind is as Ms. Gillen was providing the explanation between some of the drilling times, the idea that some of the other previously approved OGDPs that are avoiding timing stipulations is going to impact what they have going on. I will say that makes sense. The problem is we didn't really see any evidence related to that ahead of time. And admittedly, a lot of Bison's assets that they've come before us for are further away from people. So they do have a lot of the benefit of not being within 2,000 feet of RVUs and not having some of the other receptor problems that we see with other operators. But at the same time, we do often run into high priority habitat issues with them. And so the idea that some of the schedule is built around they've already scheduled around timing steps and based on consultations with CPW, I think makes sense. But I also think that it's a lot easier next step to kind of show us what they mean by that. So an example saying, all right, we have 2 rigs now. Rig 1 is going to be on location 1 from starting after this timing step date of April 1st, and then it's going to be going until October 1st, and then it's going to move to location 2. Rig number 2 is going to be on location 3 at this time to avoid a timing step, which leaves us with rig 2 having availability either before location 3 or after location 3. And so I think it would be a lot easier to show that. And so that's not to say that I'd be against approving with the COA, but I think that that's the kind of information that I think would be helpful. And one, it would be helpful in a hearing, being able to see that information and better understanding why drilling outside the ozone season is either not practicable or why it may not work and may not be practicable. But certainly in some kind of reporting, I would want to see some more verification as to what efforts were taken for that as well. That issue of the practicability aside, you know, I do see a lot of the situational reasons for the practicability assessment do make sense. You're working with a much smaller utility who's evaluating whether they would be able to provide necessary utility power to a certain area where it's not going to be used for other things. It's going to be for something temporary for drilling or be used longer term for production facilities, but at the same time, it's not something that it's going to be production facilities that the substation might be able to power other homes nearby or something else as well, and kind of be being built just for this reason. So the idea that it's going to take a while to evaluate what's going to be necessary and whether that will be able to bring power, I do understand and appreciate those arguments. I think when you look at the application as a whole, I do think there are a lot of good things with this. I mean, I think you're looking at something that they had consultation waived by CDPHE and consultation waived by CPW because they are avoiding those receptors as well. And so there's a lot of good things with the location choices for that reason. Admittedly, I'm still, and again, not a yes or no at this point in time, but a little hung up on the drilling timeline without some more information on it, I think is kind of where I am right now.
Thank you, Commissioner Cross. Commissioner Messner.
Thanks, Commissioner Cross, for kicking us off. I understand the challenges of scheduling and the challenges with working with a utility provider. You know, every developer that's ever come before me trying to do a housing development also has to deal with utility providers. And every developer I've ever talked to, you know, talks about how challenging it is to work with utility providers, right? And the housing developer, you know, is looking at similar, you know, needs and capacities associated with electricity than as a production facility or more than a production facility. And so there's planning, there's scheduling, there's working with the utility providers, there's you know, cost associated with that, both from the utility provider standpoint and the developer standpoint. I mean, this is relatively standard practice in land use. I'm a little concerned that some of the concepts that are being put in the practicability assessment, you know, does meet the off-ramp of first resort, right? Which is something that we've explicitly expressed is not what the practicability assessment is for. The practicability assessment is for situations where there was a best effort made to comply and it becomes impracticable or impossible to be able to comply. And this is where I struggle a little bit, is I'm not sure I'm finding it unpracticable to be able to electrify the production facility. I think we have an example of a electrified production facility within the CDP already. I think we have some understanding that some level of electricity is potentially available to be able to electrify some parts of the production facility. sooner than later, and that, there's a cost associated with upgrading a line and some timing associated with upgrading a line in order to be able to perhaps electrify the remainder of the production facility. The production facility ends up being the big concern for me here, because it's a permanent facility with permanent potential impacts in the ozone non-attainment area. And so I have not seen a clear plan for how this will ultimately get to electrification of the production facility. I mean, I'm hearing right now that it's challenging, and that we may be able to only do some of it, but we'll do our best efforts to do all of it. But I don't see any clear plan. Like, it's not as far along as some other ones where we've been okay with, some condition of approval because they've presented like that they're almost there. Here, it doesn't appear like we're almost there, but that it hasn't fully been, just the necessary steps haven't been fleshed out. And so I'm struggling a little bit in finding that it's impracticable to electrify, at least to some extent, the production facility. And then when it comes to the scheduling of the drill rigs, I continue, like I said, with the previous application, the ideal is to schedule the drilling rigs if you're not able to electrify outside the ozone non-attainment season. And even with a estimate, seeing this one being scheduled at the onset of the ozone season, knowing that the drilling operations would probably run clear through, or at least significantly into, the ozone non-attainment season because it's beginning at the very outset of the ozone season, doesn't seem like it's a good starting place to determine that there's going to be best efforts to not drill inside the ozone non-attainment area. If there was, an intent to look at, a January start date, a February start date, and certainly an October start date, even a September start date where you're in the very end of it, and then that it's going to continue out of it. These make it more feasible to be able to contemplate a best efforts type of COA. And I will admit, the whole best effort COA thing, I don't love that anyway. It's as we heard from the AAG in the previous one, it's a relatively unenforceable condition of approval. And so I think there's an option here, and because I do have some serious concerns, should I have to make a decision today, where I'm going to land on this. But I think that with a little more information, a little more planning, a little more scheduling, a little clearer plan on how they're going to clearly be able to get to some sort of best effort, that I could potentially be persuaded, but probably not in the moment right now. And so I think there's an opportunity to consider a continuance in order to be able to develop a plan that may tie better into a best effort condition of approval. But those are some of my initial thoughts. I think it's important to note that it's not as protective as other OGDPs that have been approved inside the Wells Ranch CDP. And now we've got to apply these ESPs as we're mandated to do. And I'm struggling a little bit to not determine that this is an off-ramp of first resort. So those are my initial thoughts.
Thanks, Commissioner Ackerman.
Thank you. And I appreciate hearing the thoughts of my fellow commissioners here. And I also wanted to reiterate that, there's some good site selection that went on here. There's some good things about this application. It's outside of HPH, significant receptor avoidance. And, there are a lot of things that operators have to comply with. And these are some very important ones. But siting away from receptors then is a double-edged sword because it often comes with working in a more remote environment that's harder to get electricity to. So I do take that into account in a practicability assessment, that there are other mitigating factors. But I also would reiterate some of my fellow commissioners' thoughts that, remote sites like this that are outside of HPH, to me, are likely those that should be very first and most considered for drilling outside of ozone non-attainment season, as electricity is hard to get there. And it's very difficult for me to ascertain the level of effort that's been made to get there. There have been various BMPs proposed here to address impacts from noise, dust, light, odor, other things that are good BMPs that we see often, but we often see when we're talking about approval under substantial equivalency. Here, that's not needed, yet there's still some strong commitments here to mitigate some of those impacts. And so I like those aspects of the application. Again, to me, it comes down to the ESPs, and I'll just be very brief, as I won't reiterate what my fellow commissioners have said. But as far as the water tank exemption goes, I'm comfortable with that. I think it's a practicable solution in this specific case to handle a very temporary capacity exceedance issue. And while I don't love it, I think a strong argument has been made and can be made for practicability of temporary site containment. Again, I would prefer to see pipeline expansion, planning for capacity, but I do understand and agree with this being a practicable solution on a temporary basis. I share Commissioner Messner's thoughts on electrifying production facilities. And I'm not saying that it is practicable or isn't practicable. It's just very difficult to ascertain from the information that's been submitted and from the testimony that's been given today as to the details of its practicability or impracticability. We've seen some initial thoughts of how many miles need to be constructed to do so. Seen some parts of the communications with the providers, but it's very difficult to make a substantiation that I think meets a legal standard of practicability or impracticability. And I think that extends to the best efforts to avoid the ozone season as well. Maybe practical, it may not be, but the burden of proof hasn't been achieved, in my opinion, to be able to substantiate that with any degree of actual disenrollment. And to the point that best efforts is a relatively unenforceable standard, I would agree. I think it's a useful standard that we use in specific instances when every effort has already been made to achieve a desirable outcome, short of being able to completely and fully commit to the achievement of that outcome. The previous application was a good example of that, as the plan was specifically planned to go outside of ozone season, but we understand that contingencies sometimes can and do arise. It's very difficult for me to employ a best effort standard if the proposed plan is already clearly violative, or at least borderline violative, of the standard that we're trying to achieve. And so I would say that I'm also in a camp where these practicability concerns move me towards a stay until, or a continuance until we really have more information associated with the details of impracticability, as is currently asserted, or some modifications that would be practicable, that would be more in line with ESPs. And my final comment would be, I get that this is a difficult conversation, and these are difficult standards and relatively new, and would reiterate that, this is something that is a result of what's been demanded by the legislature in the act, and we're doing our best to enforce what we believe the intent of that is. And so I think, once again, back to practicability assessments, and granted this was submitted before our previous discussion, but I think it goes without saying at this point that practicability assessments need to be clear when they come before us, that there are actual data that have been evaluated. If there are modifications that would be necessary to other OGDPs, kind of detailing those, like Commissioner Cross has pointed out, would help us understand practicability or impracticability. And I do understand that that could be an infinite line, but when there is no line whatsoever, other than an assertion, it's very difficult to reach a decision on a standard of practicability for me. So those are my comments at this point.
Great, thank you. Well, I will, in general, say I share many of the thoughts that have been articulated already. I don't have any concerns with the location that has been proposed. So I appreciate that part of this application, and mostly I'm focused here then on the practicability assessment and the ESPs that are in play here. With respect to the ESP related to produced water, I too feel that it has been shown to not be practicable in this case and under these circumstances. But I'm also hung up on not making that finding at this point related to electrifying for permanent production equipment and the drilling rigs. And, they're very similar to previous comments that were made, but just slightly different, I would say. For permanent production equipment, I would say in the multiple elements and criteria that we are to consider when weighing whether or not something is the ESP is practicable. One is about the availability of the grid power, and the other are a lot of other ways to sort of offset it. And I would say in the ways to offset it, I found the information provided to be much too general to be persuasive or compelling. So I'm left really with just evaluating whether the question of availability. And I think that, there was a lot of some of the information that was provided is significant and compelling, right? The amount of mileage that we're talking about, the amount of time, the cost, and some questions around long-term impacts and ability for use beyond this. So, I think there's some things there that make sense. I appreciate on this one some discussion around making efforts to at least partially use grid power for some of the production equipment in the future. Agree with previous comments that it's pretty slim on details at this point, and additional detail and information on that would be helpful to understand how much power is currently available and what amount of or what production equipment could run on either existing available line power or that could be forthcoming in the short term. With respect to the drilling rig, I will say that I would find a best efforts COA in this particular case to not get us anything at all. I would agree that the circumstances are different than cases where we have found that to be, or where I have found that to be compelling and the circumstances that would get me comfortable. In those cases, I think, those have been situations where the operator is in a situation where they are very close to being able to commit, but there is either something outside of their control or some detail that just prevents them from committing in full. But that it seems very likely that there will be compliance with what the commission is looking for in those cases. And in this case, I think. Unfortunately, I don't feel persuaded that that's the case. So I'm evaluating this, frankly, without even considering that COA. And so really it just leaves me with thinking about, the avoidance part, and has the operator made a sufficient case for us to be convinced that the schedule proposed is necessary. And so I three am in a camp where I would find additional information on that to be helpful. And so I think I'll stop there and could welcome additional comments, but could also bring up AAG Boudreaux maybe to provide some insights around this concept we're considering of a continuance to allow the operator some time to provide additional detailed information.
Thank you, Madam Chair. So under Rule 307B3, the Commission can stay the determination of an OGDP if the Commission determines that additional information or analysis is necessary for the Commission to approve or deny an OGDP. So that's an option for the Commission here today. My recommendation would be that if you all take that option, that you specify fairly clearly what it is you're looking for from Bison, so that they can have a something in the record to indicate what it is they need to come back with, which will also kind of create the, for lack of a better term, triggering point at which they can request the commission take this back up.
Okay.
A long-winded way of saying, if you want to stay this under 307B3, you can do that to request additional information to decide whether to approve or deny the OGDP.
Okay. Thank you. Appreciate that. Commissioners, questions for AAG Boudreaux or thoughts on what was suggested? Commissioner Messner.
Thanks. No questions. I think, at least on my list, should the commission choose to make a motion for staying, I think some sort of reevaluation of the schedule, with associated information on other OGDPs that may affect the kind of holistic look at the scheduling would be helpful. And while I certainly heard the applicant indicate that they feel like they brought forth a thoughtful schedule, I think there's been enough deliberation here sharing some concern about that schedule, including a start date that is, at the brink of the ozone non-attainment season. And so some reevaluation of the schedule to look at if there is the possibility of having that substantially be outside of the ozone non-attainment, if not totally outside of the non-attainment season, to a point where it would be more compelling to consider a best efforts type of COA associated with drilling operations. I think the second piece is around the electrification of the production equipment. And I think what I'm hearing, at least myself and the commissioners say, is what's potentially going to be electrified with existing capacity. What's a clearer timeline associated with gaining full capacity for electrifying the entire production facility, and what those timelines are going to look like in a little clearer way. And so a more clear solidification of the electrical capacities and timelines and what's going to be electrified and when, understanding that these are estimates, but would feed into some concept of a best efforts type of COA in the future. That's what I have on my list. I'm not sure if I missed anything from other commissioners.
Thought that was a pretty good list. Thanks. Commissioner Ackerman.
Yeah, I agree. I think that's the list that we're looking at. I just would clarify also on the electrification of the facility, I'd also be interested in knowing if it does look like we can only achieve partial electrification at the onset, what will the ongoing efforts be to and timeline be to obtain full electrification, as this will be a long-term facility that would allow for planning over a very long period of time. It would be important to pull that thread all the way out.
Great, thank you. Any additional thoughts? Ms. Wesolinki, any additional clarity that would be desired from your perspective?
Maybe just one question. I would like to talk just first about when we're continuing this to, and just make sure we're available on the bison side.
Okay.
If we could do July 29th, which is 2 weeks, that would be our proposal. And second, if this would be additional testimony to the commission at that hearing date, or if you would like something ahead of that hearing date to review prior to taking it up for that hearing date.
I I will go out on a limb and say having information ahead of time is very beneficial for us. It's hard to just obtain the information during the hearing and evaluate it and deliberate right on the spot. So that I think would be my preference. If other commissioners, if you have contrary thoughts, please let me know. Okay. Oh, yeah, Commissioner Cross.
I'll say I agree with you, Commissioner Othen. As to the latter part, I will be out of the country on July 29th, so I will not be at that hearing.
Okay. Ms. Wasilenki, is the scheduling something you want to nail down now, or is it something that you could be in touch with Hearings Manager Thomas about after the fact? Okay.
Let us confer with Hearings Manager Thomas and we can all work on a date.
Okay, great. Thank you.
I can make a motion if you like.
That'd be great.
I'll make a motion to stay this application to a date uncertain, as long as I can do that, AAG Boudreaux. Do I have to have a date certain, or could it be a date uncertain?
I think it's acceptable to have an uncertain date, so long as there's sort of clear criteria for when Bison's met the condition to get this back on the commission's agenda.
Sure. So I'll move to stay the application to a date uncertain, with the expectation, and I think the elaboration of that has been done at hearing here today, so I would hope that that gets captured as well, but to provide an updated schedule that includes a more holistic look at operations that are potentially tied to this and looks at clearer ways to avoid drilling in the ozone non-attainment season, to have additional information on what's going to be electrified, should there be partial electrical capacity, and a plan for when and how full electrification of the production facility can and will occur. And I mean, those are the two that I have, unless I'm missing something.
Thank you for that motion. Is there a second?
I'll second.
Great, thank you. We have a motion and a second. Any additional discussion on the motion? Okay. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries 4-0. Thanks, Ms. Wasilenki and Ms. Gillen. Believe that concludes our meeting agenda for today. Thanks, commissioners, and thanks everyone who's on.
I move.
Oh yeah, we have to have a motion for adjourning. Thank you, Commissioner Lester.
Second.
And we have a second from Commissioner Ackerman. All those in favor?
Aye.
Thanks.